Cam, we are streaming to YouTube.
Joe, are you able to hear?
Yes. Can you hear me, Kristen?
Yeah. Okay, good.
Good morning, everybody.
Morning.
Morning.
Good morning.
Good morning.
Ready, Cam? Okay, good morning, everyone. Thank you for joining today. Today is December the 9th. It is 8:30, and we will commence with our State Board of Pharmacy meeting. Again, thank you for joining and looking forward to a very productive 2 days of meeting. Before we start, I'll ask Dr. Gandhi to do a roll call.
Mr. Solari,
At your service.
Mr. Dang,
Present.
Mr. Minkus. Here. Mr. Leva.
Here.
Ms. Lahan,
Present.
Ms. Walmsley,
Present.
Mr. Tong, Mr. Goodman,
Virtually present.
and Ms. Nair.
Here.
All accounted for, Mr. President.
Dr. Gandhi, there's a bit of a weird echo on your screen.
Okay, we will go ahead. Let me know if that's better. I think when each other's talking here at the office. Okay, so having said that, we will do conflicts of interest. I will start with Ms. Snare.
None.
Okay. Mr. Dang,
None.
Ms. Lahan,
Yes, I have, well, not conflicts of interest. I'm sorry. I have recusals.
okay. What are those recusals?
Okay. So complaint 4A 200317. I'm sorry. I apologize. 4C 200320. 4I 200323. 4J 200335. 4L 200349. 4S 200382. 4V 200387. 4W 200309. 4X 200415. 20C 7G 200404. 7H 200413. 7I 200439. 27D and 21D as well.
Okay, thank you. Mr. Solari,
29F, and the deputy director is in possession of my form. Thank you.
Thank you. Ms. Walmsley?
President Laib, I've submitted mine in writing for the record. Do you want me to read them, or is just note them at the time?
I think note them at the time and read them if you would.
I'm recused from items 4A, 4E, 4F, 4H, 4N, 4Z, 5C, 5G, 7J, 7L, 10B, item number 3, 25B, and 27C.
Okay, thank you. Mr. Minkus, did I call you?
No, none.
Okay. And I have 7C, 7E, 12B, 13A, 18, 20C, 24B, and I have submitted the paperwork as well. And did I get everybody on here? I'm looking. Mr. Tong?
I have none.
Okay.
And Mr. Goodman.
Yes.
None noted.
Okay, thank you. Okay, before we start, I think Kim would like to tee up an introduction of our new members, and we're definitely glad to have you. So with that, I'll hand it over to you. Okay.
Members of the board and the public, we have two new board members. We had Ms. Lochnikar and Mr. Blair no longer appointed to the board, and so we do appreciate their service and time with the board as they've brought on some great information and an abundance amount of resource. And obviously we've become friends and stuff, and they'll be sadly missed. But with that, we got some two impressive people, Mr. Goodman and Ms. Lehan. And I don't think I can do them service by introducing, so I think I'll let them introduce themselves and give a little background story, if that's all right, Mr. President.
Absolutely.
So yes. I think customary to have ladies go first, Mr. Goodman, if that's all right.
Hi, good morning. I'm Cedar Lehan, and I've been in the pharmacy field since 1996 as a technician and then as an intern and a pharmacist. I graduated from Midwestern University in 2001, and I've been a pharmacist since then on the retail side of things. I've held many different positions through the company, pharmacy manager, staff pharmacist, overnight pharmacist, so I have a lot of different experience. And I'm really excited to be in this position and for the opportunities that I have to serve you. Thank you.
Outstanding, thank you. Mr. Goodman.
Yeah, it's a pleasure to be with you this morning and pleasure to serve on this board and have this opportunity. My great-grandparents, both of them, husband and wife, were pharmacists in Mesa many years ago, so have a soft spot for the industry for sure. My day job is, I'm a public member, so I really know nothing about pharmacy, or pharmacology. My day job is I'm the CEO of MomDoc, and my claim to fame, I guess, is that I am the reigning champion in the board game Monopoly. In 1999, I became the Arizona state champion, and since then, Parker Brothers has not held any state tournament, so I may end up being the board game Monopoly state champion for Arizona forever. So we'll see how it plays out. I look forward to serving with y'all.
Oh, that's wonderful. Great, thank you. All right. So having said that, we will move to tab 3, past board meeting minutes. Board members, I'll look for your comments or a motion.
We would have at least 2 recusals.
I make a motion to approve the minutes.
Okay, noting the recusals of the new board members. I have a motion to approve the minutes. I have a second.
I will second, sir.
Okay, and I have a second. All those in favor?
Aye.
Aye.
Any opposed? Okay. Moving on to consent agenda. This is section 4 through we'll do tab 4 alone, and I'll ask board staff if there's any items that need to be pulled for total board consideration on tab 4 consent agenda complaints.
Mr. President, we do have some comments and suggestions to make, but I do believe we have a sound issue and we have a pair of headphones. So while you set up, so I think under agenda 4, we do have item 4E that we would like the board to reconsider their recommendation from tabling and allowing for inspection to a conference. I believe Carol has submitted to me this morning a spreadsheet that definitively shows that there is a shortage. And I think by the time the inspection process goes through and so forth, the board at the end of the day would determine possibly a conference anyway. So rather than delay what may happen, we would suggest and recommend that the board move this to a conference.
Okay. Thank you for that. I think what we'll do now is take any other cases.
Mr. President?
Yes.
May we take a look at 4I and 4S?
Yes, thank you. Any others?
Dr. Dang, did you say S as in Sam?
S like Sam, yes.
Okay. I was going to ask to pull that one too.
Okay, noted.
It may seem like a very simple question. I'm not familiar what it means to have something be a conference. Is that similar to a formal hearing? Just clarification. My apologies that I don't know.
If I may explain, Mr. President, conference is not a hearing. It's similar where both parties come to the table and share their side of the story, and board still has an opportunity to enter into a consent agreement at that time. If they can't come to a resolution of the matter, then it can go to a formal hearing.
Thank you. Appreciate it.
No problem. Okay, any other cases, board members?
4AB.
4AB. Okay, noted. Okay, having said that, let's pick up at 4I for discussion.
Yes, so the reason why I suggest us to take a closer look at this case is because the pharmacist says when he filled the prescription, the drug-drug interaction software does not pick up the drug interaction and did not alert him of the drug interaction. I tried to put myself in the pharmacist's position, and sadly, I think I would have done the same thing as well. When I fill something, whether it's capsule or tablet, if the drug interactions pop-up screen doesn't alert me of the drug-drug interaction, I would tend to easily miss that. So for us to enforce the 3 hours of CE for this particular individual, I think it is a little bit on the strict side, if you would. So I think a non-disciplinary letter of concern would be appropriate for this particular case.
Kevin, can you expand on the drug interaction, what you're talking about? Because there is a change in formulation, but I don't see a drug interaction.
It says here that the licensee, or just based on the narrative, it says licensee or permittee responses. The pharmacist's written statement states that no drug-drug interaction were found. She noted that the patient had been titrating on and off of different mood medications over the past few months. So just looking at that statement, like me as a pharmacist, whether I'm working at the retail setting or in a hospital setting, when we fill prescriptions or enter any medications. We are nowadays heavily relying on the drug interactions pop-up screen. When there are interactions occur, the system will notify us of the interactions. And if we don't see the pop-up, we tend to bypass it. And due to the high volume, especially in the retail setting, I can see myself easily miss this particular one.
Sure, I understand that.
From capsule to tablet, I mean, that is his fault. That's why I suggest maybe a non-disciplinary letter of concern, just to remind the pharmacist that gotta be careful next time.
Yep. So this isn't a drug. That they're confirming that nothing popped up before they filled the prescription. That it's not a question of a drug interaction. A system should not pick up a formulation change because you put in that information. So I'm still not quite sure I follow the line. I'm going to open it up to Ms. Walmsley, Mr. Minkus, and Ms. Snare for any comments on what you brought forward.
Yeah, I see this more as a DUR error versus a drug interaction error per se. I guess both are technically DUR, but it would be duplication of therapy or inappropriate therapy. I know that's the comment that the licensee made, but there isn't any DUR screens or anything like that that was provided by the organization. So I don't know that we can say for sure one way or another whether that happened or not. I would be willing to consider Dr. Dang's recommendation, but I also don't think the other is unfair either, since it's not disciplinary.
Mr. President?
Yes.
I just believe, I don't see how extra CE can hurt anybody, and I think that would be, I think our decision in that was correct, and I think the CE would be only a benefit to whoever's working, so I would be more in favor of leaving that as it is, with the CE being done.
Okay, thank you.
I agree with Mr. Minkus. They missed it because it was in the SIG instead of where we're used to seeing it, that it was extended release. But I agree that CE would be appropriate.
Okay. Mr. Dang, do you wish to make a motion on this, or were your questions answered?
I do see Mr. Rubin and Ms. Nair's point, and as you all know, I am a firm believer in CE, and to me, learning is always helps our profession in many ways. But I'm just trying to put myself, I am a pharmacist working on the bench as well. I do input prescription into the computer system. And like I said, nowadays we are heavily relying on pop-up screen for drug-drug interactions or DURs. Having said that, I'm gonna stand firm on my recommendation of non-disciplinary letter of concern. I think it will serve its purpose. The pharmacist, once he or she gets a letter of non-disciplinary letter of concern, he or she will be more careful next time.
Okay. Any other discussion?
I haven't spoken, so I'll say something. I agree with Ms. Walmsley. This is not a drug interaction. This is a pharmacist should know when you see immediate release venlafaxine, which is a 3 times a day drug, come across as a once a day, you should question that. You shouldn't just pencil whip that through. So to me, that's what it seems like happened here. I would like to see the CE, and it is non-disciplinary. So 3 hours of CE is consistent with what we've done with this situation in the past.
Thank you, Mr. Moe. My final closing opinion on it is that standard of practice would be when conflicting information like this presents, that you have caps and you have tabs, that the standard pharmacist would make a phone call and clarify that. I agree with the CE. So Mr. Dang, having said that, having heard the board members, would you like to make a motion?
Okay, so I'll make a motion to go with the board's decision.
Okay, if we are not going to change and go with the board's decision, then we can move on to 4S. Okay, thank you. 4S, we have licensee failed to comply with a non-disciplinary order for continuing education.
The reason why I brought this up was because if he is non-compliant. He is fully aware of his expectation. Why are we giving him 6 months extension?
The thought process behind this with the committee, and committee members, please help me out if you recall something I don't, was that he is serving our country and he has been at a place where he has not had access to complete it. So we have erred on the side of graciousness and said another 6 months extension from 8/20 would be appropriate. And then after that date, if he doesn't get it done, then he will be before us.
Okay, thank you.
Any other questions or anything, Mr. Deng, you'd like to move forward on it?
No, Mr. Leba.
Okay.
Mr. Leba, if I may, to 4S, these are individually vetted. Obviously, it's not going to be applicable to all folks that are non-compliant with an order like this. Am I correct?
The end of each case is unique, and each case we will look at that.
Okay.
That answer your question?
Yes.
Okay, thank you. For AB, distribution of compounded drug products into Arizona without a permit.
Mr. President, we did get notice from their attorney. Their attorney is not an Arizona licensed attorney, and so they are doing I believe the term is pro hoc, looking for a local attorney to partner with. It's not, we just heard late last night, early this morning, that's not going to happen overnight. So that's where we stand right now, as far as them being able to talk to this topic today.
Was the request to pull the case?
Not from them, no, but I think you can definitely make a recommendation to go to conference at that time. That would take place in February. And then they should have an opportunity to find an attorney to partner with in this state and have a discussion with the board.
Okay.
Board members, what questions do you have?
I don't think it changes our action today. Personally, I think we move forward as planned.
Thank you. Ms. Wamsley, you cut out there in the beginning. You were just saying the recommendation was a call.
Yes.
By tabling it because they can come forward at the next meeting.
Mm-hmm. They'll have the opportunity to speak, and they've got 2 months before that's the case.
Have we issued them a cease and desist order so they don't keep shipping into Arizona?
No, we have not.
Do we want to do that till the conference? There's nothing prohibiting them from continuing to ship into Arizona without a license.
Mr. Deng, they have expressed to CAM, their attorneys expressed to CAM that they are of the opinion that they do not need a permit to ship into Arizona because they are registered with the FDA and that would give them permission. I have asked them for a written statement to that effect with a citation to the legal authorities upon which they rely for that opinion. This was communicated to them yesterday. They stated that they have a case pending before the California Supreme Court on this very issue and that he will forward me their brief that outlines that position. But again, they are not able, or his attorney is not able to present that argument on behalf of his client because he's not admitted here yet.
This is Goodman. I've got a question on the attorney issue. Is it within the realm of reasonability that they let us know just now they don't have a local attorney? I mean, would it have been more reasonable to let us know earlier? I'm not familiar with that type of an issue for a pharmacy matter.
The attorney
called someone sooner. Just asking if they could have got someone sooner.
Not all attorneys are aware that they need to be licensed in another state, although it should be an expectation that you need to be licensed in the state where you are appearing. But we have to go through this fairly often.
Okay,
Mr.
so it's a
President?
normal response to say I need to get local counsel.
Often, yes. It would occur
Thank
to
you.
most of us.
Yeah, thank you.
Mr. President?
Yes.
I did confirm, I apologize, I misspoke. We did issue a cease and desist to them. And
Thank you.
again, what Jean said was after that, so.
Okay. So not hearing any other conversation, I think the committee's recommendation for conference is still appropriate. Any other opinions before we take a motion?
Mr. President? Yeah.
Yes.
Is the cease and desist order standing or not, or is it just, I didn't hear from Elizabeth what she said.
I couldn't hear the question.
Is the cease and desist order something that we're still doing or not?
It is in place.
It is in place, okay. And that's part of what we're gonna do, okay, thank you.
Okay, so noting recusals and looking at the committee's recommendation and the adjustments made today, if you've lodged a conflict of interest, I'd ask you or recusal to not make a motion, but looking for a motion for consent agenda complaints tab 4.
Mr. President, I'd like to make a motion to approve the recommendations of the complaint committee and approve those and go forward with tab 4.
Mr. Solari, I'm sorry, I have you noted as recused on an item, so I'd appreciate it if you didn't make the motion. If someone,
I believe that was 29.
Oh, I'm sorry, you're correct. You're correct. Sorry.
Okay. So I'm good, right?
You're good.
I'll make a motion to approve, please.
By Mr. Solari, and I have a second by Mr. Dang. All those in favor?
Aye.
Aye.
Aye. Any opposed?
Okay, thank you.
Okay, thank you.
Mr. President?
Moving.
Yes.
Yes.
So that last item for AB, the recommendation, recommended action was full board. Do you want to change that recommended action to a conference? I wasn't sure about what the discussion was.
On which one?
On 4AB.
4AB. My notes say conference for shipping drugs IV into Arizona without a permit, but maybe you have something different. Committee members?
That's my recollection as well.
On the agenda right now, it says recommended action full board. So we may want to address that.
May I amend my motion on item 4AB to go to conference?
Second.
Thank you. Okay, have a amended motion and second.
Second, yes.
All those in favor?
Aye.
Aye. Any opposed? Okay, thank you. Looking at tab 5, consent agenda, refer to formal administrative hearing. I'll open it up for discussion, board members, or for a motion. Okay, having said that, I would make a motion to approve consent agenda number 5.
I'll second it, sir.
All those in favor?
Aye.
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 Any opposed? Okay, thank you. Tab 6. Agenda, Executive Director dismissals and ratification. I'd ask Mr. Gandhi just to make a quick comment on his methodology, and then we'll talk about a motion.
I believe, Mr. President, this round of ED dismissals equated to about 48 of them. And the process is quite extensive, where we open up a case file and we have a vetting process that involves a compliance officer lead, and then again reviewed by myself and Jennifer. And upon extensive discussion, we will pull out items for further review. But we felt that these 48 cases was out of our jurisdiction, and therefore no action taken or dismissed.
Okay, thank you. Board members, having heard that and having had a chance to review, is there any case that you would like to pull to discuss, or I will entertain a motion for tab 6?
I reviewed them as well, and I found the recommendations of the executive director to be in order. So I'll make a motion to approve them. Approve the tab 6, please.
Thank you. I have a motion by Mr. Solari and a second by Ms. Walmsley. All those in favor?
Aye.
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 Any opposed? Okay, thank you. Tab 7, consent agenda, consent agreements.
I'll make a motion to approve tab 7A through O.
Mr. President, we had some adjustments we needed to make on 7. If I may dive into it a little bit.
Absolutely.
Prior to the motion, I'm sorry, Kristen.
Oh, no problem.
7D, we have a consent agreement signed. However, we also had another one, 9J case. So in order to be consistent, we can't fully prove that this was not prior disclosure on this one. And so we would like the board to consider issuing an advisory letter versus a consent agreement for 7D. 7E, we would like to make a proposal to still issue a consent agreement, but modify the verbiage as Mr. Hudgens has been compliant with all the terms of the original consent agreement. Where Mr. Hudgens fell off the rail was he no longer is in pharmacy school, but still compliant with all the terms. And our current consent agreement that we have in this packet calls for unprofessional conduct, which is not the case. He is just no longer enrolled in pharmacy school. In order to adjudicate the original case, we felt that we had to do a voluntary surrender, but we would like to reword it so that it doesn't reflect unprofessional conduct and simply that he's no longer in school. So that would be 7E. 7I, 20-0439. We have an interim consent, I believe, involving Mr. Nye, and correct me if I'm wrong, Jennifer Elizabeth is. We need an updated consent agreement that reflects another monitoring substance use program with retroactive to the original consent, which I believe maybe 2 months ago or so, but retroactive to the initial consent agreement. I think those are the adjustments I'd like the board to consider.
Okay, thank you. Hearing that, board members, they sound like reasonable adjustments to make to the consent orders. I'll open it up to you if you have any questions.
I'll amend my motion to include the suggestions made by staff.
Okay, and I have a amended motion. Did I have a second?
I'll second that, sir.
We will
Okay.
need a roll call because they involve discipline.
Thank you. Dr. Gandhi?
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
I am noting my recusal.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Okay, thank you. Moving on to tab 8, consent agenda and special request. 8A, permitting name diabetic apothecary. defer to board staff if they are here, or if this is simply just a extension of a permit, asking for the 9-month extension that's allowed.
That is that request, Mr. President. It's nothing that we haven't seen before, so it's just a routine request.
Okay. Board members?
Make a motion to approve.
Second.
I have a motion by Ms. Snare and a second by Ms. Walmsley. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you. Tab 9, consent agenda, license, permits, recommendation. And these were items with Ms. Walmsley and myself and board staff prior to making it to the packet. If you look at each case, you will see the recommendation on the subject line, and I'll give you a second to look. If you don't have any items that you'd like to pull and discuss, I'd look for a motion.
Mr. President, I have five of them that I'd like to just discuss. I don't necessarily disagree with the recommendation, but I wanted a little bit of clarification.
Okay.
A, B, H, I, and L.
A, B, H, I, and L.
Please.
Okay. Any others? Okay, 9A. And Mr. Solari, I'll let you go ahead and drive.
Okay. Mr. Kruger did not disclose his conviction on either renewal. So why are we approving this without giving him the $250 civil penalty? He had in 2016 and 2018, he had convictions, and I did not see him disclose those.
Let's see here, because staff
was
was
come forward, right, and note it. He just didn't. That's how I read that. I'm sorry to interrupt, Mr. Leyva.
no, that's okay. Mr. Solari, the discussion related around this was a case where staff could not say 100% fact that he didn't disclose in the first place. Therefore, erring on the side of the safeness and for Mr. Kruger, we decided that an advisory letter would be more appropriate.
Very well. Okay. 9B, I requested that pulled. That was offer a consent agreement for a $1,000 civil penalty. I found the $1,000 civil penalty to be a little bit excessive, and I wanted to reduce that to the $250 civil penalty. Pharmacy cooperated with the board requests, shipped no product into Arizona while they were delinquent. So they were cooperative once we got in touch with them, and I'd like their penalty reduced from 1,000 to 250.
Ms. Walmsley and Dr. Gandhi, do you have any comments on that, on the discussion related around that? I think Mr. Solari makes a good point. I think 1,000 in the type of permit was our standard approach, but noting they did not ship, I do think 250 is reasonable as well. But
I think 1,000 is typically what we do for a permit, but I would be open to looking at the other.
Board members, what were your thoughts on this?
$1,000 seemed typical of what we've done before, so I don't have any thoughts either way.
I'm looking for my additional notes, Dr. Leyva. Hang on one second. I'm good with it. Yeah, it was just based on the customary nature of the prior fines.
Okay, Mr. Solari, I'll move it back to you.
I'm okay with either one, but I just thought 1,000 was a little bit excessive. I was going to cut him a break for good behavior. If the board members don't feel that way, that's okay. If they don't think that's appropriate, that's okay. But that was my thought on
Okay, I think we have the recommendation. If you feel inclined to change that, then we would need a motion and a vote. That is up to
No,
you.
that's fine. Leave it alone. Okay, sorry.
No apologies needed.
Okay, let's go to H, Geodis Logistics. I think, and the representative Robert Schutt did not disclose DUI on the application. And this was another one where I was wondering why we're not giving the 257 penalty for non-disclosure. Question 5, they did not disclose.
This, if I recall, and Ms. Walmsley and Mr. This was a individual, a company who had a outside service fill out the application. The outside service was unaware of Mr. Schuth, who is a non-pharmacist and does not work in the pharmacy directly. He's in the business side of it. Know of the infraction in April 11th of 2016. So there was literally we felt comfortable that that permit holder had no knowledge of that, and it was purely an oversight on the contracted company that filled out the license. Having said that, at the end of it, it was the responsibility of the permit to review the entire application. And if they review it and they don't know because Mr. Schuth does not come forward and told him that, that's where we came up with the approve the application with an advisory letter. Ms. Walmsley.
Yep, that's exactly the case. That we felt like there was really no way for the company to know that, since this individual doesn't hold a fingerprint clearance card or any of those kinds of things as well. Felt like this is a little bit of a unique situation since he is a non-licensed individual himself.
Very well. Okay. Next one is 9I, Guadalupe Pharmacy. They answered no on discipline. There is a Mr. Marcos Solomon, who is the officer owner in a Nevada pharmacy. They should have disclosed discipline by California. Does Mr. Marcos do compounding at the Nevada pharmacy? If he does, yeah, no one does. Marcos, does Marcos do compounding? If so, we need his last inspection.
So
if
the recommend
Solomon is going to come and do compounding at the Nevada pharmacy, do we need any kind of a inspection report from his, because he was disciplined?
We did request the inspection on November 20th, and we did not receive a response.
And part of the recommendation is for the executive director and deputy director to review that, and if find it satisfactory, approve the permit.
So we did request that. Okay, very well. And then,
but if the inspection is not satisfactory, they wouldn't approve it and they would bring it back to us.
Or if there was concerns, yeah.
And then 9L, Compounding Pharmacy of America, not clear. I wasn't clear what your recommendation was. Seems we need a $250 civil penalty for non-compliant, for non-disclosure, but I can't really, there's a recommended action in bold and there's an update below it. I'm not sure where we're going.
Okay, recommendation is request the staff to with the FDA Form 483. Also, it may be helpful to pull the most recent inspection. If that is satisfactory, offer a consent agreement for $250 civil penalty with standard terms. If applicant does not sign, deny the application.
Okay, and then there's some updates below it.
Yeah, I believe we received an email last night from staff.
Okay, and that was, okay. That was the guy that said he can't show up because of COVID?
Yes.
Okay, very well. Okay, thank you.
Okay, thank you. Looking for a motion on tab 9 consent agenda.
I make a motion to approve tab 9.
Okay,
Second.
Thank you. I have a motion by Ms. Nair and a second by Dr. Dang, and we will do a roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus, Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Okay, thank you. Board members, moving on to tab 10, consent agenda, license and permit ratification. After you've reviewed and have time, I will entertain a motion.
I'll make a motion to approve tab 10.
I'll second it, sir.
Okay, thank you. Have a motion and a second. All those in favor?
Aye.
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 Any opposed? Okay, thank you. Tab 11 is vacant. Tab 12, resident pharmacy permit applications requiring board review. 12A, Meta Pharmacy Solutions. I'll look to board staff.
Mr. President, we do have another conference with Glendale Pharmacy. I believe Meta Pharmacy and Glendale Pharmacy are connected somehow. And so we would like the board to consider to hold this agenda item, table it until we have a chance to discuss the Glendale Pharmacy situation.
Dr. Gandhi, I 100% agree with that recommendation. I think there are many questions that are unanswered related to that complaint. And given the fact that the two are related, I would prefer that we table this matter until that complaint is resolved, because it may impact our ability to act on this permit.
Ms. Walmsley, did you want to address it at the same time? I think that it's going to be recommended for a conference at the next board meeting. Would you like to address it at the same time?
Yes, that would be my preference.
Okay, I'll ask that
I'm
we
willing
pull
to make
this.
that my motion if
And
needed.
I'll second that. That's
Okay.
very reasonable.
All right, have a motion and I have a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay. 12B, I will ask Ms. Walmsley to take over as I am recused.
Ms. Walmsley, before you open it up, I know Sharon, our compliance officer, would like to share some comments regarding this agenda item.
Yes, sure. Ms. Huss, would you like to give a brief summary and share your concerns?
Hi, this is Sharon. I just wanted to clarify on the blurb about the ownership for Cordis Pharmacy. I just wanted to make a clarification on the ownership. It indicates that the owner of the pharmacy and their spouse are prescribing practitioners, which is not accurate. There's two separate ownership issues. One of the owners is a physician. The second ownership issue is the husband of a practitioner. So it is not a spouse and a practitioner that are both prescribers. It's the spouse of a practitioner and then a separate practitioner that are owners.
Okay, thank you. So board members, the matter at hand is we have a resident permit application for Cordis Pharmacy. There is a one physician that is a partial owner of this facility. Dr. Gandhi, do we have anybody present from this applicant?
Yes,
to
you
give
do.
a statement or answer questions? Can you please introduce yourself and state your affiliation, please?
Hello, ladies and gentlemen. My name is Jason Dykstra. I am the owner of the majority owner of Northern Arizona Pharmacy. We do operate two pharmacies. We've applied for a permit for the third one here for Cordis Pharmacy.
Thank you, Mr. Dykstra. Are the other owners from your business present?
They are not present.
Okay. There is a requirement in Arizona that a physician is unable to profit from the ownership of a pharmacy. Can you please explain the relationship of your owner that's a prescriber and how they interact with your pharmacy, please?
Sure. So one of the owners of the pharmacy and the physician, he works for the VA in Phoenix. He does not prescribe out of this facility any longer. He did for a short time, and he's been made fully aware that that is an unacceptable practice, and that we cannot accept prescriptions from him. And I was assured that that's not even going to come into question since he's not writing out of this facility anymore.
Thank
And
you.
as far as the spouse owner, this particular pharmacy is about 30 to 35 minutes from their practice. I did bring this up to them, and they did say that they don't have patients out that way and that they don't foresee this being a problem at all either, of even writing for a patient. And we would know that we can't accept them.
Thank you. And Mr. Dykstra, you mentioned that you also own 2 additional pharmacies. Are these individuals partial owners of those facilities as well?
They are. It's the same company.
And what is their relationship from a prescribing standpoint? Is that the same in those facilities as well?
Well, so this is definitely something that I've talked to Sharon about and need to address. When we originally applied for the first pharmacy, it wasn't brought up to the level of what it is now. After speaking with Sharon, we had discussed that there were some cases that set precedents on this and things like that. And everything that Sharon has brought to my attention has been enforced. We have adjusted our practices to keep in line with what the board has asked, or that Sharon has asked as well. So we know we don't accept any prescriptions from the physician. It was kind of recent news that Sharon had spoken to me about the issue with the spouse prescriber, and that's something that we're currently working on to get fixed. And as she clarified some things with the kind of defining exactly, trying to find the right word here, but defining exactly what the board's requirements are for that. That's something we're currently working on. We did not realize that the spousal issue, that the spouse was an issue for taking some prescriptions. So that is something that I can honestly say we're currently working on at our other facilities as well.
Thank you, Mr. Dykstra. Board members, any additional questions?
I don't have any questions, but previously we had a case where there was a veterinarian who was the owner of a pharmacy, and he wrote a statement, he wrote a letter saying that he would not write or have the pharmacy fill prescriptions for him. And we went ahead and approved that permit. And perhaps a similar letter would be in order here, both for Dr. Gillum and the prescriber, who's Mr. Jaramillo's spouse. If they wrote a letter saying they would not prescribe and have their prescriptions filled at any of the pharmacies that they own, we could probably go ahead with this permit, approving this permit upon receipt of those letters.
Your mind is going exactly where mine was as well. Additional comments, board members?
If there isn't, I'll make that motion. Have these prescribers write a letter stating they will not send prescriptions or have their prescriptions filled at any of the pharmacies that they are owners in. And upon receipt of those letters, I move to approve the permit.
Second.
I have a motion by Mr. Solari and a second by Mr. Minkus. All those in favor?
Aye.
Aye. Any opposed? Thank you, Mr. Dykstra. Appreciate your time.
Thank you.
Thank you. Moving on to agenda item 12C, Talus Harbor at Yuma.
Yes, good morning.
Good morning. Please state your name and position for the record.
Sure, yes, my name is Natalie Lamberton and I am CEO for Talus Harbor Healthcare.
Welcome and thank you for joining us today.
Mr. Labo, you're very difficult to hear.
Okay. Thank you for joining us today.
Yes.
Is that better?
Yes, much better.
Okay. Tell us a little bit about the nature of your request before the board today.
Sure. Last year, we were building 2 geriatric psychiatric hospitals with a 24-bed footprint, and we requested a deviation from the 500 square feet requirement for the pharmacy. That was denied, and we since built the hospitals with that 500 square feet and have discovered that we have more than enough room and that we need probably a little less than 2/3 of that space to adequately run the pharmacy. So we're building another hospital in Yuma, Arizona. We've requested if we could have a deviation of 310 square feet for that pharmacy. I apologize, my pharmacist has taking her daughter to an appointment today and was unable to be on the phone or on the Zoom with me, but she did submit a letter and some pictures so that you could see how large the pharmacy is, and that she attests that practicing in the pharmacy for the last year, we've got more than enough space to do it in 310 square feet. We do no compounding, no complex things like that.
Okay, thank you. Board members, I'll hand it over to you for any questions you may have.
Mr. President, may I?
Yes.
Ms. Lamberton, I just wanted to make sure this is a hospital that's not going to do any surgeries. You don't have an emergency room. No procedural stuff like endoscopies or anything that might. Okay. Absolutely not. Do you have plans for expansion?
For this hospital? No. It's 24 beds and will remain 24 beds.
What will you do with the additional space should the request be granted?
We will probably use it for office space.
Thank you.
Yes.
Mr. President. Mr. President.
Yes.
Do you have, you haven't built this yet, so have you already submitted the plans and everything for this?
No, we have not built it yet. Plans have not been submitted. We wanted to come to the board first.
And the only reason you don't think you need the room, and you would turn this into office space, is that correct?
Yes, office space or perhaps auxiliary space, something like that. We've already got the 24-bed footprint. It's just such a small hospital. 500 square feet is huge. And if you go to our location in Bullhead City or in Phoenix that we're about to open, both of those footprints are 500 square feet and the space is just cavernous. And the pharmacists have attested that they just don't need that much space.
Okay, thank you.
Mr. President?
Yes.
So, Ms. Natalie, you mentioned about the other 2 sites in Phoenix and where else?
Bullhead City, Arizona.
Bullhead City. What are the, how big are those facilities? How many beds do they hold?
The Bullhead City, Arizona space is 24 beds. And the Phoenix space, which we just got certificate of occupancy for, is 40 beds. It will be our only 40-bed location. The rest of the hospitals, including Yuma, the one that we're speaking of today, will only be 24 beds.
Okay. So have you guys considered of needing extra storage spaces for IV fluids? Because IV fluids comes in bulk packages.
We have considered that, and we still have adequate space.
Okay, so here, this is my concern. Coming from micro hospitals myself, now I'm also managing mid-sized hospitals. So keep in mind, a facility of one of my facilities, 16 beds hospital. Although then at first, to me, when I first started working at this facility, I thought 16 beds, that is a small hospital. Yes. But then when we ran into the situation of having IV fluid shortages, we had to find spaces to make sure we can store the NS solutions. We have to store the potassium containing IV solutions, and all these liter bags come in big boxes. And we up until today, we still don't have enough space to store these large, bulky IV fluid boxes. And as a hospital, you cannot operate a hospital without NS liter bags, without potassium containing IV solutions. So to me, 40 beds facility, you would definitely need a 500 square feet space pharmacy, and even 24 beds facility, you would need that. Trust me, you will. And,
Okay.
and just to add on to this, all these potassium containing fluids, they have to be securely locked. They cannot be stored in any storage spaces that can be accessible by other non-pharmacy staff. What I'm sharing with you is the Joint Commission guidelines, not
Sure, and
something I make up.
No, I understand that. And we've been in operation for a year. The 40 bed is a 500 square foot, and our 24 bed in Bullhead City is a 500 square foot as well. We're just asking that we're able to do 310 for the Yuma location, which is 24 beds. And we've been in operation for Bullhead City for a year and have had more than adequate space with that operation, seeing, gosh, I don't know how many patients we've seen in a year's time, but many patients. And we just have this huge space in the pharmacy that goes unutilized.
So with the current situation, I am totally comfortable with the request, but when you, in critical situation, when you have to stock up IV fluids, especially potassium containing IV fluids, where are you gonna stock these? If we were to approve this deviation request and it comes to, let's say next year when one of the plants gets shut down because of whatever's going on, what are you gonna do? Where are you gonna stock these potassium containing IV fluids?
I still attend to, and my pharmacist thinks that we will still have adequate space in the pharmacy. Right now, we use less than half of the pharmacy with 500 square feet. That 310 is roughly 2/3 of the 500 square feet, and we would still have that adequate room and space.
So, Mr. President and board members, like I said, I'm comfortable with the request, but my main concern is when at the 300 square feet pharmacy space with the 24 patients beds, my only fear is this facility will not have a designated space to safely and securely store the potassium containing IV solutions. And all this are mandated by CMS and Joint Commission.
Mr. President.
Oh, I'm so sorry. I didn't mean to interrupt, but we're very aware of the CMS guidelines. And when we had our Arizona surveyor come out for Bullhead City, we of course abided by all of those. And so we're aware of all the CMS requirements and guidelines and Joint Commission as well.
Mr. Dang, perhaps I am comfortable with the request as well. And I see your point. Perhaps a grant of the deviation request under the 24 bed capacity is something that you could propose. Having said that, Mr. Solari, I'll take your comment. I think you were going to make one.
Yes, sir. Ms. Lamberton, you don't have ER, OR, procedural stuff. How much IV fluids do you use?
To date, I don't believe we've used any.
Okay. The additional space, you said should the request be granted, you said you were going to use the space for office and what else?
Perhaps auxiliary space, like it's a psychiatric hospital. So for group therapy, individual therapy, things like that.
Should it become necessary, could you knock down those walls and rededicate that space back into the pharmacy?
Oh, absolutely.
Okay. Then I think I agree with Mr. Dang. I'm okay with approving this. And in fact, unless there's other questions or comments, I'll make a motion to approve this deviation request.
Okay, I have a motion. Any other conversation, board members?
No, but I'll second.
Okay, I have a motion and I have a second. All those in favor?
Aye.
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 Any opposed? Okay, thank you for your time today.
Thank you so much for your time. I appreciate it.
Thank you.
Mr.
Board
President.
members, it is 9:30 and we're going to take a
Mr. President,
quick break.
before we do a break, I just want a clarification on 12B. If we can go back to Cordis Pharmacy, I see Mr. Dykstra is still online. Just want a clarification that that letter that Mr. Solari recommended in his motion applies to all the pharmacies that they own, correct?
That's what I intended. I wanted to make sure all three of the pharmacies or any pharmacies that may open in the future would be included.
Okay, I appreciate that. Thank you, Mr. Solari.
Yes, sir.
Okay. Having said that, we will take a 10-minute break and return with tab number 13.
Because one kid who probably finds and pops up, but he's not in school, we want to take out unprofessional conduct. You know, that be qualified because he went. Yeah. What the other one was, but yeah. Yeah, I have, no. I can go back to my God, I mean, it's a Throwing you on the spot. Are you?
Well, I know, I'm sure.
All right, welcome back, everyone. We will pick up where we left off at LifeScript Pharmacy, but I will ask Dr. Gandhi to do a roll call.
Okay, Mr. Solari,
Present.
Mr. Dang,
At your service.
Mr. Minkus,
Here.
Mr. Leba,
Here.
Ms. Lahan,
Present.
Ms. Walmsley,
Here.
Mr. Tong,
Here.
Mr. Goodman,
Accounted for.
Ms. Nair.
Here.
Perfect. Thank you.
Okay, tab 13, 13A. I'll ask Ms. Walmsley to lead the way. And I do believe we are going to table this to the next meeting, but
Yes, let me pull up my notes here. Actually, Dr. Gandhi, can you give a brief, or Jennifer, give a brief recap of what's going on with this and kind of the ongoing complaint?
Certainly. We do have an ongoing complaint against a pharmacy that's related to LifeScript as an affiliation. And there's a request for this application to be withdrawn. And our recommendation suggestion is to not consider that request just yet until we've had an opportunity to sit down with the complaint, which is Lakeside Pharmacy, to have a discussion with them and then make a determination whether you'd like to have them withdraw or any other consideration at that time.
And that complaint is scheduled to be heard at the February meeting, correct?
That is correct, yes.
Okay. I think that's a very reasonable explanation, and I think the complaint may have bearing on how we handled this particular application. Board members, any additional comments or questions for the staff? Hearing none, do I have a motion?
I'm willing to make the motion to table this request until the February meeting.
Do I have a second?
Second.
Motion by Mr. Solari, second by Ms. Snare. All those in favor?
Aye.
Aye. Any opposed? All right, thank you.
okay, thank you. Moving on to agenda 13B, preferred prescriptions pharmacy. Mr. Gandhi, was there a representative?
We did notice them to appear. I don't see them. Looking at page 2, one moment. I do not see them on our website on a Zoom meeting, Mr. President. We'll keep an eye out for them. If we want to just continue on, I'll look for them.
Okay, that sounds good. 13C, Apex Pharmacy.
I see.
There
we go.
I'm David Eleftarian, one of the owners of Apex Pharmacy here in Beckley, West Virginia.
Okay, welcome. Good morning, David.
Good morning.
We have a full board on the virtual meeting here to hear your request today. Tell us a little bit about what you're wanting from the board members.
We're just wanting permission to be able to ship meds into Arizona. We work, do with doctors' offices, specifically cataract surgeries, to get patients medications as cheap as we can in a timely fashion as well, in accordance with what the doctors usually request.
Okay. And what board staff, could I ask you to give a little background on the permit application before us today?
Would you like me to do that, Mr. President? This is Sharon.
Yes, Sharon, thank you.
Sure. So I conducted the substantive review of the application for Apex Pharmacy. In conducting that review, there were a couple of items that we felt warranted a review by the board versus doing a blanket approval through the executive director that we thought the board should take a look at. A couple of those surrounded discipline of the permit and some 483 issues from the FDA. There had been a 483 issued from the FDA in 2019 to the permit. The FDA 483 observations in 2019 surrounded the use of non-approved products, non-approved FDA-approved products and compounds, an observation of the pharmacist not wearing gloves, and for a damaged scale. There was some discipline of the PIC for theft of prescription drugs. That was back in 2014, however, so it is substantially dated. It was greater than 5 years old. There was of greater concern was some discipline in the home state of the permit holder for intentionally outsourcing medications, prescriptions without obtaining FDA outsourcer registration. There was in that discipline noted in the home state from the pharmacy board that on opening inspection, they had stated that they would not be doing any outsourcing. They would only be doing patient-specific prescriptions, in that they did not want to obtain FDA outsourcing registration due to the cost of that. On a subsequent board inspection in their home state, it was found that they were doing a significant amount of outsourcing, and they were subsequently disciplined for that. On review, it appears that they still do not have any 503B registration with the FDA. It's not known if they are currently doing only patient-specific or if they're currently still doing any 503B filling of prescriptions at this point. There was also discipline on the permit for shipping into South Carolina without a non-resident permit. They still do not have a South Carolina permit. Again, we don't know if there's any shipping into South Carolina occurring. These disciplines were disclosed for the applicant location and for the PIC. It looks like there was another known other owned location in which the discipline was not disclosed for us, but those were our concerns that we thought the board needed to review rather than us approving the application at that time.
Okay, thank you, Ms. Richardson. Mr. Eleftherian, would you like to make a response to that?
Sure. Originally, the inspector that we had in this area, probably up until about 2 years ago, we would, there were meds that we were doing for a local hospice. He recommended putting it under a patient-specific John Doe for the patients of hospice, and so by recommendation of the board, that's what we were doing. When the new inspector came, he said, no, you can't do anything like that, and we said no problem, and we stopped doing that at that time. But that was we had been doing that for a good number of years, which is obviously why it reflected in there saying that we were doing non-patient specific medications to these to that local hospice house. Since then, we haven't done anything like that. And when the FDA came in 2019, they when we showed them records that were 6 months back, they looked obviously pretty deep, and there were still some from that time. But since then, nothing has happened. I believe we stopped doing anything like that in March of 2019.
Thank you. Board members, questions? Mr. Eleftherian, can you confirm for me, are you shipping any type of compounded medication in bulk to an end user?
No.
Everything that comes out of your pharmacy is patient-specific, label-specific?
Correct.
Okay.
Other question. Do we know what states you have licenses in currently?
We're currently licensed in several states, not all involve compounding, because a lot of we really do the compounding only here. But some states will require you to do, if you're applying for one, you have to apply for everything that you do, basically. So we're licensed obviously in West Virginia, Ohio, Pennsylvania, Indiana, North Carolina, Minnesota, Illinois, and Colorado. But the only states that and I don't think any of North Carolina, there's an option, like you still have to show everything, but I guess there's an option to where registered with them, we're telling them we're not sending any compounded medication to them, because we don't ship anything. It's really the only things we do here locally.
So you're not licensed to or permitted to ship into South Carolina?
Correct.
Mr. President, may I?
Yes. Yes.
Hello, sir. Mr. Eleftherian, do you have a CBD distributorship?
Yeah, inside of our pharmacy, yes.
Would you elaborate on that? Would any of that come to Arizona? Any?
No, and we named our this side company, I guess, CBD distributors, and that has become confusing as people think we are an actual distributor of CBD products. We just purchase them and sell them here for local use.
Thank you.
What type of products would you be shipping into Arizona?
It would just be eye drops, manufactured eye drops, things that you could get really at any pharmacy. But what we do, we get a lot of manufacturer coupons and that kind of thing, which usually ends up saving people money to use us versus their local pharmacy.
So manufactured products only, nothing that you would be making that would be
Correct.
like a sterile-based compound or anything?
No,
like
no,
that?
we don't do sterile compounding at all.
Okay.
And are you currently a 503B?
No.
No. What was the story with South Carolina when you shipped?
I believe it was when we first opened. The PIC that was here at the time, I believe he thought because we had applied, he was okay to start sending stuff there. So he had, and at that time, I think we were doing sterile compounding as well. So what he had made had gone to South Carolina. As soon as we were told that we couldn't do that, obviously we stopped. And then I think regulations came into account for as far as shipping out of state anyway. And we, I think at the time, decided not to pursue sterile compounding on a larger scale that way.
Mr. President, it's Kevin.
Yes.
So I have a question from David. You mentioned that you ship the eye drops to Arizona?
Correct. Well, I mean, we don't now, but we would like to. Yes.
Okay, so to my understanding, and I could be very wrong, eye drops need to be prepared in sterile environment with sterile.
No, we don't compound them. They're just manufactured ones.
Okay, manufactured by other.
Yeah, like ordered from our wholesaler that we send out. Yes.
So if I'm understanding you, this is really just a traditional retail pharmacy that you would be shipping across state, like community pharmacy that you would be
Correct. Correct.
across state lines, essentially.
Yes.
Okay, board members, any other questions? If not, I'd entertain a motion.
Mr. President, I'm satisfied that they meet requirements. I'll make a motion to approve this permit.
Second.
I have a motion by Mr. Solari and a second by Mr. Dang. All those in favor?
Aye.
Any opposed? Okay, thank you for your time today.
Thank you, board. I appreciate it.
Okay, moving on to agenda item 14, resident wholesaler permit applications requiring board review. That is vacant. We'll move to 15, non-resident wholesaler permit applications requiring board review. 15A, Women's Choice Pharmaceuticals, Inc. Is there a representative from Women's Choice Pharmaceuticals? I'll defer to board staff.
Mr. President, this is Sharon. Women's Choice Pharmaceuticals, we have an application here for a wholesaler permit in which the wholesaler was already permitted with us. We discovered that they had a permit that was closed for non-renewal. We found that they had moved their wholesaler permit from Mississippi to Pennsylvania, did not notify us that they had moved their location and continued to ship prescription products into the state of Arizona. So they changed locations without notification and did continue to ship.
Okay, thank you. Board staff, were there any communications with the permit that they would appear today? I think there are some questions board members need answered.
We did notice them like we would have any other appearances, Mr. President. I don't see them on page 1 or 2 of our meeting.
Ms. Richardson, wasn't there also a change in ownership?
What we discovered during this also was that they own a company called Edwards Pharmaceuticals. And we have Edwards Pharmaceuticals is permitted with us as well. And there's no disclosure on the permit for Edwards Pharmaceuticals that they have any relation to Women's Choice. So that's kind of a separate issue as well.
Okay, board members, I would suggest that we table this, and if they do appear later, we can come back to this agenda item. Otherwise, we'll have to table it till we can get a representative on the line so we can ask our questions. Moving on to tab 16 is vacant. Tab 17, non-resident manufacturer permit applications requiring board review. First one is ADMA Biomanufacturing LLC. We have a representative from ADMA Biomanufacturing. I'll defer to board staff.
Does not look like they're on, Mr. President.
Okay, this is Sharon again. So ADMA Biomanufacturing is applying for a non-resident manufacturing permit with our state. They are again, doing the substantive review, there were some concerns that kept us from approving it through the executive director, some issues we thought that the full board should review before approving it. When doing the review, we discovered that there was currently an open permit at the address for which they were applying. This permit belongs to Biotest. This permit was issued in 2008, was most recently renewed in 2019, and is currently valid until October 31st of 2021. I contacted the applicant, ADMA, regarding this and discovered that they actually had acquired Biotest in 2017. And according to the applicant, Biotest had not operated at that location since 2017. A change of ownership application had never been filed by ADMA, and a notification was never made to us by Biotest of a change in ownership. In addition, on their renewal application in 2017 and 2019, Biotest attested that there had been no change in ownership. In 2018, the board was notified by Biotest that they had an officer replacement. And at that time, they stated that, in fact, there had been no change in their business structure or ownership. ADMA has confirmed that they have been shipping into Arizona from this location since they acquired Biotest in 2017, and they have actually been shipping in Biotest labeled product. In 2016 and 2018, ADMA were issued FDA 483s. The 483 that they received in 2018 included 8 observations, and 2 of those were reoccurrences of observations from the 2016 inspection. I was able to get a copy of the 2018 report from the FDA website, and they did provide, ADMA provided a copy of their response to that 483, which is in the packet. They did not provide a copy of the 2016 483. They stated that that fell under Biotest. So our concerns that we wanted to present to the board was, number one, a permit cannot be opened for ADMA since there is an active permit at this location right now under Biotest. ADMA has been shipping into Arizona since 2017 without a permit. Biotest continues to renew their permit at this location, stating that there has been no change in ownership. If Biotest was acquired by ADMA, a change of ownership was not completed as required, and it's not really clear why Biotest continues to renew their permit. And if ADMA did acquire Biotest, Biotest also did not do the required notification, and in fact, in 2018, stated that there had not been a change in their ownership or business structure. So those are the concerns that we have for the board to consider.
Thank you, Ms. Richardson. I appreciate that. I'm aware now that somebody with ADMA Biomanufacturing is in the room. If you could state your name and position, I would appreciate that.
Yes, hi, I'm Adam Grossman. I'm President and CEO of ADMA Biologics.
Okay, welcome to the board meeting.
Thank you for your time.
Thank you. Mr. Grossman, you heard the synopsis that Ms. Richardson just gave. I'd like to give you an opportunity to answer to some of those topics that were brought forward.
Sure. Thank you again to the board for your time. Ms. Richardson, I heard what you said. The one thing I would like to say is that ADMA did not acquire Biotest. We acquired assets from Biotest. Biotest considers to be a going concern and an operating entity separate from that of ADMA Biologics. We acquired their drug manufacturing plant and the rights to produce and commercialize certain assets, certain products made in that facility. So we did not acquire their actual corporate entity. It may be a little technical and legal, but that's I've been dealing with this since June of 2017, and it's an important piece of information there. It was not a stock acquisition, it was an asset acquisition. With that being said, just some history. We were a contract manufacturing customer of Biotest Pharmaceuticals prior to the acquisition of these assets. We acquired these assets because Biotest did not operate the facility in compliance with all the FDA regulations. Me and my company, we acquired these assets, and we've been working very, very diligently and hard with FDA. And we're pleased to report that in early 2019, the FDA granted a new establishment license to ADMA Biologics for the Boca Raton production facility, which I believe is what we're applying for under this application, the 5800, 5900 Park of Commerce Boulevard, Boca Raton, Florida indication. We have a new license separate from the license number that Biotest was operating under. Additionally, we have resolved all outstanding compliance issues, resolved all 483s with the FDA, and that's why we are now operating in compliance. You're not the first state that we've had these conversations with. This is certainly something that is not a simple or straightforward answer to give you. I can also say that when we acquired the facility and the assets from Biotest, there was an agreement called a transition services agreement in place with Biotest Pharmaceuticals. This is normal and customary. I haven't done this many times in my career, but this is normal and customary, as I understand it, when pharmaceutical companies may acquire assets and or products from other pharmaceutical companies. And we were operating under a transition services agreement, which ended this past summer. I want to say it was August of 2020. Under this transition services agreement, and this is accordance with the FDA because the FDA authorized the use of the Biotest labeled product, NABI-HB, that product is still in compliance under the FDA rules and regulations. So under this transition services agreement, we continue to operate in compliance with FDA rules and laws. I do not have information on Biotest responses to the state of Arizona. I do not have copies of how they maintain their interactions with your board. So I do apologize for that, but they operate as their own entity, and I'm responsible for ADMA Biologics. I can tell you that we are appearing before the board today because we are an FDA compliant manufacturer of life-saving plasma-derived drugs. There are patients in your state who rely on our products, and some of our products are newly approved by the FDA as of April and May of 2019. These are all now under the ADMA Biologics labeling. I can also report to the Arizona Board of Pharmacy that all the products which ADMA Biologics currently manufactures are labeled with ADMA Biologics name and license number. And these are the products which we would like to have authorization to continue to provide to your state. They are made in compliance with FDA rules and regulations. We are in good standing with the FDA, and we are operating under our own compliant FDA licenses.
Thank you, Mr. Grossman. Just a confirmation statement from me and more of a question. Since the expiration in August of the service transition agreement of management, how are you shipping now into Arizona?
So we ship products through Cardinal. They act as our 3PL out of Tennessee. So all shipments would be sent using the same process that was in place when Biotest was operating and in control of the facility. But the shipments which we are making into the state are coming through Cardinal.
Okay, and this permit would allow you to ship direct to end user. Is that what you're?
We don't ship to end users. We ship to sites of care. So we would ship either to pharmacies, hospital pharmacies, hospitals, infusion centers, or physicians' offices. We do not ship any products directly to patients. All of the products which we manufacture are to be administered in the presence of a caregiver. So they're mostly intravenous infusions that would be performed in a licensed healthcare facility.
Okay, that answers my questions. I'll turn it over to board members.
Mr. President, may I?
Yes.
Hello, Mr. Grossman. The address, you have the same address as Biotest Pharmaceuticals, is that correct?
No.
On your permit, are you able to change that so that whatever your address is not the same as Biotest?
So again, if I may, just to clarify, Biotest Pharmaceuticals no longer operates out of 5800 Park of Commerce Boulevard. Biotest has moved their offices to a separate location. We currently are the owners and do operate at 5800 Park of Commerce Boulevard.
Okay, what you're telling me is that the non-compliance is on the part of Biotest because they're still using that address, not where they don't reside.
I do not believe that I'm in a position to say who's in non-compliance, but I would say that what you just said is an accurate statement.
Okay. You have not had a license in Arizona, but you've been shipping into Arizona since 2017. Is that correct?
We have been shipping under the terms of the Transition Services Agreement in accordance with the FDA labeling regulations. And yes, we have been shipping since we acquired the facility in June 6th, 2017. So since that date, shipments have been made into Arizona through Cardinal using the licenses of Biotest Pharmaceuticals under the Transition Services Agreement.
And I'm not sophisticated enough to understand what all that means, but how much product are you shipping into Arizona?
It's not very much product. I mean, the product that has been commercially available since 2017 is a specialty product called Nabi-HB. It's a hepatitis B hyperimmune globulin that is used for post-exposure prophylaxis of healthcare workers, people who may be cohabitating with others with a hepatitis, those who have potentially been sexually assaulted by a hepatitis B positive patient, or to babies born to hepatitis B positive mothers. Just to give you an idea, the product does about $5 million a year in revenue, and that's across the entire United States. I don't have the sales figures in front of me, but I would garner to say a few $100,000 worth of drug every year would have been sent into the state of Arizona. Since our FDA approvals for our immune globulin products, Bivigam and Asceniv, those products are intravenous immune globulins indicated for the prevention of serious infections in immune compromised patients with primary immune deficiency disease. Those products, again, we are still in our first year of commercial ramp up in sales, but it would be, a few $1 million worth of drug, enough doses to treat maybe, tens of patients in the state of Arizona.
Just an easy question for board staff, without going into executive session to get legal advice. This transition of what is the term you used for shipping into Arizona, Mr. Grossman? You said you're using your 3PL at some transition of care.
So Mo, it'd be similar to when a retail pharmacy or a different type of permit, when there's an acquisition and they are allowed legally to continue to serve customers under the original permit. So that is something that we could see. But I guess that would be my point, Mr. Solari, is perhaps that is something that we request from Mr. Gross, director, deputy director, the chance to review that if everything falls in line and is, as Mr. Grossman has stated, which I assume it will be, that this application is granted at that point. That would be my opinion.
That's where I was headed as well, and I agree with that.
I agree as well.
So I'll make a motion for Mr. Grossman to submit the shared services agreement, and not shared services, the shared management agreement with Biotest to the executive director and deputy director, and upon review, the executive director and deputy director to approve the application.
And that would be the transition services agreement that I spoke about.
Sure. And Mr. Grossman, that would be dated this past June?
No, the transition services agreement would be dated June 6th, 2017. but I'm not, that's the date that we closed the transaction. I believe it would be June 6, 2017 would be the original date of the transition services agreement with Biotest Pharmaceuticals.
And that expiration in August.
That's correct.
Board staff?
So if the transaction took place in 2017, Mr. Goodman, and we're in 2020, why did it take such a long time to apply for an Arizona license?
So I believe that we applied earlier this year. And the application may have been as far as last year. It may go back to last year. I don't have the date of the applications here. Part of the issue is that it stems around FDA and our home state, the state of Florida, as I understand it. We did not receive final labeling and FDA review and comments and approval until, call it, the middle of 2019. And then we needed to apply first for our home state licenses. The state of Florida issued a license. We had a number of things that we had to clean up with respect to Biotest and their dealings with the state of Florida. I've been cleaning up the mess of Biotest for the last 3 years, candidly, and that's why it takes so long. But once we got our home state license, then we were able to then initiate the process to apply for individual state licenses. I'm not our licensing expert, but to the best of my understanding is that these things take time. Hence, that's the reason for these transition services agreements that are, as explained to me, are normal and customary. We believe that we have been operating under the FDA rules and regulations, as well as the rules and regulations of in conducting an interstate commerce under the fact that the product was still labeled with Biotest's name on it until 2020. So we have just recently began printing labels with ADMA Biologics' name on the NABI-HB drug. So all of these things take time. These are not things that are just quick and easy. You can just throw a new label on the product. They require FDA review. We're now in a place where all of the products that we are producing, all of the packaging and labeling now contains the name of ADMA Biologics. So that would be the best answer I can give you there.
Mr. Grossman, you had mentioned that other states have brought this concern.
I'm sorry, you're on mute, sir.
Thank you. You had mentioned that other states have brought the concern forward when you've applied for new permits, non-resident manufacturing permits. What were the outcomes of those states?
We have received every state permit that we have requested thus far. I wouldn't say that there were, they were more questions rather than concerns. Just, hey, can you explain this to us? And I tell the truth. It's all documented there. We're just trying to do the right thing here, clean up someone else's mess and make good products that help people. So that's the best answer I can give you. Every application, the best of my knowledge, every single application that ADMA and its subsidiaries have applied for has been granted. There may be a little bit of hoop jumping, but they've all been granted.
Thank you, Mr. Grossman.
Mr. President, just for educational purposes, typically a management agreement between two companies only exists in Arizona if, of course, a transaction takes place and a new company has applied it. So that management agreement serves as a bridge. And this may be an anomaly to that process, but that's how the normal process would work. So if the new owners did not apply, you can't necessarily form that bridge. But like Mr. Goodman had some, like he said, cleanup to do regarding the transaction.
Just a little.
Okay, thank you. So there is a motion on the floor. Did I have a second?
I'll second.
When I have a second, any other discussion?
The only thing to consider after this vote would be, what do we do with Biotest?
Okay.
Could
All those in favor?
Can we clarify, this is Goodman, can we clarify the motion since there's been a lot of discussion since the first motion?
Yes, the motion that has a first and a second is to have Mr. Grossman submit to the executive director and deputy director a copy of the executed shared agreement, and upon successful review, the ability for the executive director and deputy director, if there are no concerns, to grant that application. Okay, so I have a motion and I have a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, Mr. Grossman, thank you for your time today.
Thank you. So we will submit that and we look forward to hearing from the board. Thank you for what you do and stay safe.
Thank you. You as well.
Thank you very much.
Now I will defer to board staff to pick up on the conversation. It sounds to me like it's a possibility of a complaint being opened on by that. I will hand it over to board staff for their opinion.
I think Mr. Goodman, between the lines, did state that Biotest unfortunately is still operating. And I just verified the permit information. It is still open under that physical address that Mr. Goodman stated. And if they have moved and operating at a different location, they haven't notified us of such. So they may be shipping to Arizona from a location that's not permitted today.
Do you need a motion, or can there simply be an investigation and then a complaint opened if there is something found on the investigation?
I don't think we need a motion, maybe just guidance from you guys. Is that the route that you want to go?
It would be my belief, board members, for the
Direct the board staff to do an investigation.
and determine if Biotest has indeed violated the rules and regulations in Arizona.
Agreed 100%.
And Mr. Gandhi, I think it's Grossman.
Grossman, I'm sorry.
Okay, moving on, 17B. This is Exiliad Inc.
Did we need to vote on that? Was that or
that's just guidance on that one. There's no motion or anything.
Okay, thanks.
But did we get a vote on the other issue of granting it, presuming he submitted?
Yes.
Okay, there is.
Yes, we did. Yep.
Do I have a representative with Exiliad present?
Sorry, I was muted. I did see them earlier. Just looking for them again.
Yes, I'm here.
Yes, they're here.
Okay, welcome to the board meeting. If you would please state your name and position for the record.
Yeah, my name is John Rigg. I'm the CEO of Exiliad.
Good morning and welcome. Mr. Riggs, you're in front of us for a non-resident manufacturer permit application. I'm going to ask the board staff to provide a little bit of background on the application, and then I will follow up with your statement as well. So with that, board staff, could I, and I'm not sure who, if it was Sharon, who it was involved in this one, could give me a little bit of a background for board members as well.
Mr. President, I can probably dive in and speak to it. At the September meeting, the board did allow Exiliad to withdraw their application and work with board staff to reopen their expired permit. Since that time, we were given some additional information stating that there was change of ownership, and it might be a licensing group that Exiliad had partnered with that may have supplied us that information. I also know that the owner came before the board, stated that there was no change of ownership. So we have two different statements here. One from a licensing group and one from straight from the horse's mouth, if I may. So that's where the conversation is today.
Okay, thank you. Mr. Riggs,
Having heard that,
was there a change
of ownership, and what statement do you have to make?
Yeah, ultimately there was no change of ownership. We're a privately held company. It's a family held. Kabatz's based out of Rome. The 5 family members manage Exiliad through a set of A set of things in 2000 is related to a meeting of signature financial.
Thank you. So that answer not a change of ownership, and I will hand it over to board members at this point. Board members, having heard that, it is my opinion that we should grant this application. There is sometimes miscommunication between the company and the outsourced licensing group. Mr. Riggs has gone on record saying that there was not a change of ownership, and I am comfortable with the application.
I agree. I would be comfortable with making a motion to approve as we have and keep our prior decision.
Okay, so do we need any action on this? I'd look for legal counsel on that, or the grant from the last time is as is, stands as is.
I would go ahead and reaffirm the granting of the application.
Ms. Walmsley?
Can I just verify something? So this is, I think the last recommendation was that you were going to have them withdraw the application and renew the old application. Because
Yes, I believe that's correct, because there wasn't a change of ownership. And we've clarified that for the record again today. So I would be in favor of allowing them to continue to renew their prior permit and withdraw this application, since there was not a change in ownership.
I'll amend my second.
Okay, I have a motion by Ms. Walmsley and a second by Ms. Snare. All those in favor?
Aye.
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 Any opposed? Mr. Riggs, thank you for your time today.
Yeah, thank you, board. Thank you for your patience on this. Thank you.
Thank you. Agenda item 17C. This is Gale Medical, Inc. Do I have a representative for Gale Medical?
Hi, Joe. It's Falcon Patel. I have George Pogorski and Eric Walter. I'm the Director of Quality for Boston Scientific. George Pogorski is going to represent Director of Quality for Galil, and Eric Walter is the Senior Quality Engineer for Boston Scientific. The reason why Boston Scientific is here is because we've acquired Galil Medical.
Okay, thank you, Mr. Patel, and welcome to the meeting. May I ask the board staff to give an overview of the application and any concerns that we may have? And then, Mr. Patel, I'll come back to you and ask you for your statement if you have one.
Okay.
See, the concern, Mr. President, the board had is we have been in communication with Galil Medical, and they have been responsive up to a point where we asked about shipping into Arizona without a permit. And at that point, we were not able to get the additional information we requested. The applicant has requested the withdrawal of their application as they no longer ship into Arizona now.
Okay. Mr. Patel, I'd like you to make a statement and include in there if you have shipped without a permit into Arizona and when was the last time, and I'll hand it over to you.
Okay, so we have requested the withdrawal from the board because we are shipping via our Boston Scientific Distribution Center into Arizona. So that facility that we're shipping into is licensed to ship into Arizona. Hence, we no longer needed the permit for Galil. So when we acquired Galil back in 2019 of August, and Galil is a manufacturer, was part of a overall acquisition that we had under BTG. So BTG was the main acquisition we did in August 2019, and Galil was one of the subsidiary of BTG. As we moved the distribution into Boston Scientific Network, we no longer need a separate license for Galil Medical. And when we went to withdraw the license, that's when we saw that there was an application for a license for Arizona.
Thank you. Have you shipped product into Arizona in the last 2 years?
Yes.
So you shipped without a permit during that period of time?
No,
George,
that would have been done under the existing Galil Medical Inc. license.
And would you please state your name and position for the record?
Yeah, I'm George Pogorzelski. I'm the Director of Quality for Galil.
Okay. Now, state that again. So my question for board members, so we're all just completely 100% on the same page, is who shipped your product into the state of Arizona during the last 2 years?
Galil Medical would have shipped product under license M001553.
I just for reference, the M001553 is not an approved permit. It's actually the one that you guys are considering today. It's the application.
Oh, I'm sorry. I thought that was a renew of the existing one because we had a previous one. Do you
No.
show up a record of that prior?
No.
Ms. Dodge, when did that previous permit expire?
I don't see a previous permit for Galil.
I apologize. I must have gotten the wrong information.
And I think that's why we were thrown off, because in an email to me, you said that you had shipped product in the past 2 years from Galil Medical. And then when I started asking questions about that, you stopped responding.
That was to me, Elizabeth?
I was dealing with Nancy Shaw, and Eric Walder was also included.
Yep. Hi, Elizabeth. Eric Walder here from Boston Scientific as well. So we, in the February timeframe, took over the licensing for Galil Medical as part of the distribution integration into Boston Scientific. I believe that's when that license application was submitted in March there, when we were starting to clean up some of the licensing activities there. However, the distribution integration into Boston Scientific was completed in April. And that's why we're considering the withdrawal of the application at this point, as it's no longer needed for the current state of operations.
So Mr. Walder, I see that you're requesting the withdrawal, but I'm still not comfortable that for the past period of time, there was shipment into Arizona, reaching Arizona residents that was not tied to a permit.
Yeah, I'm going to have to look into that further. I know we did have a customer base in Arizona. Specifically, I'm aware of the Mayo Clinic as one example where we did ship product directly. So I apologize. I'll have to get more information for the board.
This be something that we could come back to this afternoon if time permits.
Yes.
Mr. Laba, just for my clarification, if they're wanting to withdraw an application, oh, no, never mind. I just answered my own question. Sorry, I got a little confused.
No worries. Board members, I propose we allow the representatives to kind of align and then come back this afternoon if time permits. And just at that point, ask our other questions. Yes.
Just to be clear, right? The product being supplied by Galil Medical is a medical device, not a pharmaceutical, but it does still apply to this license. Is that correct?
It's prescription only.
Okay.
Can I ask just a couple of questions in case they want to find answers to these as well? I don't know who Biocompatibles Inc. is and what their relationship is. Same question with Porzio Life Sciences. These are the names I saw in the reading, and what is their relationship to this license?
So Biocompatibles is BTG PLC. That's the company that Boston Scientific acquired, for which Galil Medical was a wholly owned subsidiary. So it is possible what you're saying there is the connection that the product was being distributed by Biocompatibles, which is part of Galil Medical.
Okay, and then who's Porzio Life Sciences?
Yep. So Porzio Life Sciences is the third-party vendor who manages all of our licenses within the state. So they help us with the applications and the submission of the applications into the state.
Okay, and why did they not respond to Dr. Dodge's requests and went silent? Can you speak for them?
Yeah, so they reached out to us, and that's, before we could reply back, we're up in front of the board here because we didn't know that we had a March application, and because we had Porzio submit the application to withdraw prior to, so that was the in between there.
Okay, thank you.
For the record, it doesn't look like that. You requested it right after I asked those questions, but all of that information is in the board book.
That's how I'm seeing that as well, Dr. Dodge. Okay, we will come back to this and hopefully hear some more information if time permits this afternoon. 17, thank you. 17D, Blue-Eye Pharma USA. Permit application M001639. Do I have a representative for LUYE Pharma USA?
I do not see him in our meeting, Mr. President.
Board members, do you have any additional questions? We could talk to get clarified by board staff. We can move forward with this application, or we can table and come back to it.
Mr. President, my only real question really for the respondent would be who takes possession of the drug before it enters Arizona? Is there any change of ownership of the product or not? I don't feel like that has really been very well clarified for the record, but that's really my only remaining question for the respondent based on the materials.
Yeah, Ms. Wamsley, I had that as well. The response on page 2364 says that they do take ownership at the 3PL. What's unique is that the ownership that they're taking is coming from the parent company as well.
And Mr. President, this is Sharon. We actually received two different answers from them. When on their initial application, they indicated that they would be, when they were told of their options of getting their product into the states, they indicated that they would take possession of the product, which as a virtual, they cannot do. They would no longer be a virtual wholesaler if they did that, or a virtual manufacturer. So they initially said that they would take possession of the product. When I questioned them on that, because they would not be applying for the right permit if they did that, they then told me that their CMO would ship, which is their contract manufacturer, would ship directly to a 3PL, which if they did that, that is not going to work without that CMO having an inspection, a CGMP inspection. So when I asked for clarification on which way they were actually going to go with this, they went silent, and I was no longer able to get responses from them. So that's where we're at with them.
Okay. Perhaps board staff could reach out to them and see if they can join us this afternoon so we can move forward with this. If not, we will have to table it. Okay, tab 18 is vacant, tab 19 is vacant, leading us to tab 20, renewal applications requiring board review. 20A, Don Adine Hayden. So board members, this is, we can take action on this without a representative being present. I just want to give it one more time. Anybody for Dawn Adine Hayden? Okay, this individual has a valid, had a Arizona license, had another license that was revoked in Idaho, I believe, or surrendered. She surrendered that license, not revoked. And that was some of the questions that brought the application before us. And I will open it up to board members, board staff. If you'd like to make a comment on it, you're more than welcome to as well.
Mr. Leba, if I'm not mistaken, she's also asking to withdraw the application now. She had originally requested to renew. We had some additional questions, and now she's asking to withdraw.
Mr. President, may I?
Yes.
Best I can gather, she self-disclosed she hasn't done anything wrong in Arizona. And because of that, I'm okay with allowing her to withdraw her renewal application. I assume that would mean that the application would then expire and become invalid. And so, not invalid, but closed. And so then that would be the end of that problem or situation. So unless anybody else has any questions or issues, I'm in favor of allowing her to withdraw.
Second.
Okay,
So
was that a,
let me make that my motion officially then, so then Ms. Snare.
Yeah.
Allow her to
Jumped the
withdraw.
gun a little. Yeah. Okay. Yes, I second that, Mr. Solari.
Thank you, ma'am.
okay, I have a motion and a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you. 20B, Laura Sigrid Riley. Is Miss Riley present?
Mr. President, she appears to be there, but trying to speak, but the volume's not coming through.
Miss Riley? Why don't we ask board staff to speak to the renewal application, and hopefully that'll give her time to fix that.
Cam, is there something that Mr. Curtis can do to unmute her?
I'll figure out.
Unmuted.
Now, if we want to just talk to the next person, if we can, I'll get a hold of Ms. Riley.
Okay. Board staff is going to try to get a hold of Miss Riley. We'll go to the next 20C, and then we'll bounce back to Miss Riley. 20C, Marikar Zers. I will be recused and ask Miss Walmsley to lead.
Thank you, Mr. Leba. Is Ms. Pons present on the call? Board staff, is Ms. Pons available?
Looks
I
like
see her,
she's
but
there.
it looks like she's muted also.
I'm here.
Ms. Pons, are you there?
Yes.
Hi, can you please introduce yourself for the record, please?
My name is Marikar Ponce, and I'm a pharmacist.
Thank you. Board members, we have two agenda items before us today relating to Ms. Ponce. First and foremost, I believe we should address the complaint that's open against her license first. Then we also have her license renewal application that we will need to address today. Mr. Gandhi, can you provide, you or another member of staff, provide a summary of the complaint, please?
It may be helpful. I believe Dennis is the one that has this complaint. I'm not sure if he's available.
Yes, I'm here.
Okay, go ahead. Thank you, Dennis.
So we received a notice of termination from Ms. Ponce's employer, Walmart. Having received a copy of their investigation, she was terminated for overcounting a couple of prescriptions, as well as changing quantities on cyclobenzaprine prescription. Police report was filed with the city of Winslow. It's unknown if charges were ever brought. I did contact Ms. Ponce via email. We did receive a response from her where she disputed some of these accusations, and that's where we stand.
Thank you, Mr. Wagner. Ms. Ponce, would you like to make a statement regarding the complaint?
As I have explained in the email, there was a miscommunication with regards to the prescription for the cyclobenzaprine. The doctor actually called me like a couple days after, like 3 or 4 days after, telling me that she's not approving the 90 tablets for 30 days, but 30 tablets for 30 days is just what she's only approving due to it may cause like too much sedation. And I unfortunately mistakenly filled the prescription already for the 90-day supply, which actually was for the whole prescription of the cyclobenzaprine, but I did not forge anything with regards to that. And I did have refills for my lisinopril, so there was really no forging on any of those prescriptions.
Question.
Yes, go ahead, Ms. Nair.
So you're saying there were 30 and there were 2 additional refills and you filled all 90?
Yes.
Or are you saying that yes, okay. But the doctor said that they did not want you to get 90 at one time?
Yes.
And you're saying that you filled the prescription before the doctor authorized it?
No. She made a clarification that she only wants it for 30 tablets for 30 days.
And you'd already filled the prescription?
Yes, ma'am. And that was the mistake that I made.
Had it left the pharmacy at that point? I mean, you had filled it, it had been clarified. Was it clarified the same day? You had it?
It wasn't. She called me like 3-4 days afterwards with regards to that one. And I didn't know what to do at that time.
Why was it clarified? What brought about the clarification?
Because I kept on calling her with regards to that, because I was also asking for a refill of my trazodone, in which I already got ahead of that cyclobenzaprine. And she didn't want me to have the cyclobenzaprine for 90 tablets for 30 days because of the sedation. That's what she was saying.
But why were you calling for clarification on it if you...
Because she had previously given me 30 tablets for 30 days. So that was like the first time I requested for that one. And I only spoke with her medical assistant.
I just guess I don't understand why you would fill it for 90 if you thought that she was only okay with giving you 30.
No, ma'am, I requested for 90. I specifically stated in the fax 90 tablets for 30 days. And she made a clarification like 3 to 4 days after, stating that she was only approving for 30 and not for 90.
Ms. 90 for 30 days, not 30 with 2 additional refills?
No. Yeah, she was only approving it 90 tablets for, she's only approving it 30 tablets for 30 days instead of 90 tablets for 30 days.
Oh, okay. That's different than what I originally asked. Okay.
And for clarification, did the doctor file the police report against you?
No.
Who did?
It was Walmart. I don't know. I don't know if they did, because I never got any warrant or anything.
Mr. President, Madam Vice President, may I?
Yes, please.
Ms. Ponce, is it customary at your pharmacy for pharmacists to fill their own prescriptions, or are there other pharmacists that should be doing this instead for you?
I was the only one assigned at that day, and it's been like for like the whole week, and there's no other pharmacists over there.
I see.
Yeah, because normally when the other pharmacist comes in, I will be assigned for like straight 5 days or sometimes 6 days straight. And then when she comes next, I will not be there and I will be in Phoenix because that's not where my usual home is. My usual home is in Phoenix. I'm just renting an apartment over there, and I have to look at my house down here in Phoenix because nobody lives here. Nobody lived here for a year when I was working there.
Wait, Mr. Solari, I just want to say, did you answer his question? Is that the policy that it's okay for you to fill your own prescriptions?
I've done it before, so I never got corrected or anything for that. So I assumed it's okay for me to fill my own prescription. I mean, it's never a controlled substance anyway. So I normally ask my pharmacy manager or any other pharmacist to fill my prescription if it's some kind of like a controlled substance or anything. But when I had my surgery, it was another pharmacist who was assigned over there. So I got my prescription for the other pharmacist over there.
I am a bit uncomfortable with your description or explanation. You have a home in Phoenix, you have a place in Winslow, you choose to fill your own prescriptions. I realize that both cyclobenzaprine and trazodone are not controlled substances, but you know, as a pharmacist, they are kind of sedating and they have additive properties. In addition, you have overfilled, or they have alleged that you have overfilled your prescriptions for Montelukast and your estradiol, and it just makes me uncomfortable that there's more going on here. Any explanation why this is happening? Ms. Ponce?
Yes, sir.
Any explanations why? Are you denying that you overfilled your prescriptions intentionally?
I did.
Okay.
But I have like excess refills into my prescriptions.
But correct me if I'm wrong, board members, according to the information that we received from her prior employer, when she was interviewed, she admitted to the fraudulent prescription as well as overfilling the prescriptions due to her financial hardship. And I believe we have that statement in writing. So that is not consistent with what she's telling us today.
That's where I'm having trouble with as well.
That is also an issue.
Well, we were hoping to come here and resolve the issue for us.
That is also an issue.
Yes.
So did you, was the prescription for cyclobenzaprine fraudulent or not? You admitted to your prior employer that it was.
It was only for one time that I filled that for 90 tablets for 30 days, but it should have been like 30 tablets for 30 days.
That's a yes, I assume. You're saying yes, you did incorrectly fill it. Okay, thank you.
Did you or did you not overfill the prescriptions for yourself?
I did, ma'am.
Okay, thank you.
What have you
Board
learned?
members, what additional questions do you have?
Ms. Wormsley, so Ms. Ponce, how did Walmart become aware of the constant overfill of your prescription? Has there been a pattern in the past?
No, sir. I only did it for like one time. I think it's because my pharmacy manager was leaving and she did her inventory and all that. So that's how she caught it.
I'm still not fully convinced just because the cyclobenzaprine is a non-controlled substance. Yes. And for Walmart to bring this up to our attention, that just convinced me that there must be something else is going on. There must be a trend or pattern pertaining to how you have been filling your own prescription at the store. Is there anything else you want to share with us so that we can help you? Something that we should know?
It's just one time because she was leaving at that time. And I thought that when I got called in, they were going to, let me know about who's going to be the next pharmacy manager or something like that. But I was just surprised when she was like introducing me of, overfilling prescriptions for other patients and all other stuff. And I said, I never overfilled other prescriptions for other patients. And then when she told me, I will be direct with you, so it's your prescription, whatever. And then I admitted it and I said yes. So they put me on suspension. And then they made me wrote like the statement and stuff. And then after they suspended me for 2 weeks, they told me I'm fired from my job.
So has there been a large quantity of cyclobenzaprine went missing or something? Otherwise,
That was the only time that I did that one. That I did a 90-day, 90 tablets for 30 days for that one.
okay. Thank you.
Board members, any additional questions?
How long have you been a pharmacist?
Since 2009.
2009.
And this was the very first time I've done this thing.
Walmart is your employer, has been your employer
Yes.
since 2009?
No. I work at different pharmacies. I no longer work for them.
And you've always been an Arizona licensed pharmacist?
Yes.
You've not practiced in other states or had
No.
other disciplinary problems?
No.
Thank you.
Ms. Ponce, where are you currently employed?
I'm not employed right now.
Oh.
So going back to board member Solari's question that he had asked you, aside from the cyclobenzaprine, you have also overfilled other prescription meds for yourself. Is that correct?
Yes.
Can you be honest with us and let us know which other medications?
Lisinopril, Montelukast.
What's the quantity to?
90-day supply, but that's it.
What else?
Estradiol,
Quantity?
90 for 30 days.
Anything
I'm sorry,
else?
90 tablets for 90-day supply.
Anything else?
That's it.
What about the Montelukast?
Yes, I mentioned that.
You said lisinopril and estradiol. So lisinopril, estradiol, and Montelukast.
Montelukast, yes.
All for 90 days.
Yes.
So given Ms. Ponce's admission both to her prior employer and to us today, I think that some action needs to be taken. I believe in prior cases similar to this, we have issued a suspension as well as a probation and fine related to these types of matters. I would be willing to entertain a motion at this point if somebody would like to kick one out there.
I have a motion, but I need my colleagues' input. So there are 4 prescriptions that she had overfilled for herself. And we have, my suggestion is to incorporate a fine of $250 per prescription. So that's total, that comes out to be $1,000 fine. The reason why I mentioned $250 is because we have been charging or we've been fining other applicants $250 for not disclosing things that are required by the board. So that's just some suggestions that I have.
May I help with that?
Yeah,
please.
go ahead. Go ahead, Mr. Solari.
Okay. Yes. In the past, we've done a fine, we've done a suspension, and like Ms. Walmsley said, a probation. We've had people who have taken controlled substances that have received heavier discipline. This one is non-controlled substances. I agree with Mr. Dang's fines. I'd like to, in addition, see if he's willing to, while he's making a motion, add a suspension of 3 months with another 9 months in addition to that for probation for a total of 1 year. At which point she needs to come in front of the board and apply to have her license reinstated or the probation taken off.
I like that, Mr. Solari. So can you sum it up in all?
So we decided on $250 fine per prescription for a total of $1,000, a 3-month suspension of her license. At the end of the 3 months, she needs to come and apply to have her license, the suspension removed. And then she will serve an additional 9 months of probation. At the end of the 9 months, she will come and request for her probation to be lifted.
Is that a motion?
That's your motion unless you. want me to-
Okay, that's fine.
And I'll
So,
second that motion if that's okay.
yes,
I have a suggestion. Should we add a clause if she doesn't sign the consent? What would be the next phase?
And if she doesn't sign the consent agreement, we'll go to a hearing.
that would be my motion. Thank you, Mo.
So motion by Mr. Deng. Do we have a second?
Well,
On the
just
second.
before there's a second, if we can get clarification, what is the time frame for payment of this civil penalty?
Let's say 90 days.
90 days at the end of her suspension, sure.
She has 90 days after the suspension?
No, at the end of the suspension, the 90 days is over. She needs to have paid her fine.
Okay.
90 days from now, or yeah, 90 days from the beginning of the suspension.
Okay, so, and you had, if not signed, go to hearing. This is also on here for the renewal application. You could offer a consent, if not signed, deny the renewal. That takes care of both issues. If she signs the consent, do you want to approve the renewal?
At the end of the suspension, she can then, when she requests for the suspension to be lifted, we can approve the renewal with a 9-month probation. So I see your point. Yeah.
Ms. Galvin.
So she's suspended for 3 months, at which time she comes back to the board, seeks permission to have the suspension lifted. If the suspension is lifted at that time, her renewal would be granted.
With a 9-month probation.
That makes sense.
Can I ask a question?
Please.
Do I just call the state board or do I need to go to the state board?
Ms. Ponce, we have not voted on the motion yet, so hang tight, and we'll have we can have the staff follow up with you after we decide on the matter.
Okay.
Ms. Galvin, Mr. Hargraves, is that motion clear? Is there any other further clarification that we need?
Her license, because the application for renewal was submitted in a timely manner, her license will continue until you decide on the renewal. In the interim, that license, if she signs the consent agreement, will be suspended. And when she comes back and seeks the suspension lifting, then the renewal will be granted and it'll be put on probation for 9 months. So part of this was just me talking through it. So I don't think we need anything else.
I just wanted clarification on the, so typically with renewals, we continue to renew their license, meaning we extend it out a little bit longer to give them time to sign the consent agreement. How long would we like to give that amount of time for her to sign the consent agreement?
1 month, 30 days.
I'm fine with that. I'm fine with that.
Is that an appropriate time for staff to get it out to her?
She would have 30 days from the time we get it out to her.
Oh, okay.
To decide whether to sign it. That's a generous amount of time.
And we have some A-grade AGs working on it, so that's not a problem.
So before we vote, let's just recap the motion one more time to make sure everybody's clear what we're voting on. So the motion on the table is a 3-month suspension, at which point in time she would have to appear before us again to have the suspension lifted. Following a 9-month probation, for which she would have to appear before us again to have the probation lifted. In the meantime, her license is open and active until she receives the consent agreement for both the fine for $1,000, $250 per occurrence for the inappropriate activities related to her own prescriptions. If not signed, we would move to hearing. And her license obviously would not be in good standing at that point in time. Is my understanding of the motion correct?
Thank
Would
you for
that
summing
be,
it up. Great.
if not signed, go to hearing, or if not signed, deny the renewal?
I think we would need to do both because we would need to address the activity if she's not willing to sign the consent agreement.
Well, I think you'd be addressing it by the order of denial, which she could then appeal. Jean, am I correct on that?
I would agree with that.
Okay.
All
right.
That was the motion, Mr. Dang. That was the motion.
Yes, that was a motion.
Okay, correct.
Any further discussion?
We do need a roll call.
Yes.
Mr. Gandhi, go ahead.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leba is recused. Miss Lehan? Miss Lehan?
I'm recused.
You're recused also. Miss Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Miss Nair?
Aye.
Ms. Ponce, the staff will follow up with you to answer any questions that you may have. Thank you for your time and attendance today.
Mr. President, we may have figured out 20B if we want to give that a try one more time, please.
Okay, thank you. 20B, Laura Sigrid Riley.
Can you hear me?
Yes.
Okay. All right, good.
Welcome.
Sorry about all that.
That's okay. Would you please state your name for the record?
My name is Laura Sigrid Riley.
Okay, you are here today for a pharmacist license renewal application. Can you tell me what you would like the board to know?
Yes, I was put on probation in Kentucky because we had extended BUDs on some sterile veterinary ophthalmic and one inhalation product. I had based the BUDs on reference materials. They said we cannot do that. It had to be 24 hours. So that day in October when they came in, we immediately stopped making them because 24 hours didn't make sense for the treatment.
Okay.
We would have had to make them every single day and it just wasn't, we couldn't treat anything like that.
So Ms. Riley, this took place, hang on one second. Kim, could you mute?
Yes.
This took place in 2015.
2019.
2019?
Yep.
19. And so you were still under probation.
That's right.
Okay. And what is your intention with the renewal of your application to Arizona? Are you intending to practice here?
No, I licensed in 18 states. I'm just keeping my licenses up. We're in the process. I live in Kentucky. We're moving back to Michigan, actually. So I will be practicing, hopefully, in Michigan.
Okay. And you signed the terms of consent, which included a fine, probation, PIC restriction, training and sterile compounding, and some CE. Has all of that been completed in the timeline allotted besides the probation?
Everything except for the live sterile CE. I'm haven't been able to do that yet. I have till February to do that because of COVID. There hasn't been a lot of options for live sterile training.
Well, so you're compliant with the terms thus far. Is it with Kentucky?
Yes.
Okay. So board members, this is just my opinion on it, and I'll turn it over for conversation. If she violates the consent order from Kentucky, we would be notified or should be notified. So I don't see that there would be a requirement on our part to do reciprocal discipline on this one. And that is my opinion, and I'll turn it over for the board to discuss.
Mr. Leba, I agree with you. I don't think she poses a danger to the citizens of Arizona. And to your point, if she were to violate her agreement, we would be notified and we can take action at that point in time. So I would be in favor of allowing renewal of her application.
Board members, any other discussion?
I'll make a motion to approve.
I have a motion to approve. Do I have a second?
Second.
I have a second by Mr. Minkus. Any other discussion before a vote?
Mr.
All those,
President,
yes.
Mr. President, should we also ask her to send to the board the documentations as an evidence that the live sterile compounding CEs are completed whenever she has it done?
We can. It might be a little bit tricky with what's going on out there because I don't think many places are offering live CE in a compounding environment. But Kevin, you would probably have more experience with that than I would, so I would defer to you and Mo on that.
Mr. President, if I may also, it is the consent agreement from her that was issued to her. And so if she's deficient in that, again, we'd be notified.
Yeah, I don't see any reason to go through unnecessary restrictions here. Just let her do her thing. If once she completes it, we're done with it. If she doesn't complete it, we'd be notified and we can readdress it or open a complaint at that time. So I'm good with it as is.
Okay, so I had a
So if she
motion.
doesn't get it, so if she doesn't get it done, then Kentucky Board of Pharmacy will inform us. Is that what I'm hearing, Cam?
It would be failure to comply with a consent agreement or an order.
Okay.
And that would be another complaint issued and more hoops to jump through for Ms. Riley. And then, yes, that would be reported to the national database and we would be made aware of it.
Thank you. Okay.
Okay, so I have a motion. I have a second. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you for your time today, Ms. Riley.
Thank you very much. Take care.
Mr. President, if we can backtrack to preferred prescription pharmacy, they have logged in. That's 13B.
Okay, agenda item 13B, preferred prescriptions pharmacy. If I have a representative in the room, could you please state your name and position for the record?
Lynn, if you can request them to unmute. I do see them, but they're muted.
I'm sorry, Cam. Who?
Hello.
Yes.
Hi. This is Preferred Prescriptions. Are you able to hear me?
Yes, we have you. Thank you.
Okay. Sorry about that. My name is Fedja Temem. I'm the pharmacist in charge and also a partner.
Okay, thank you for joining today. If I could get the board member that was processing the application to give a brief synopsis on the concern, that would be great. Cam, can you walk us through this?
I think this is a similar situation that we've run into previously with a medical practitioner owning and being compensated by prescriptions. And by our statutes, ARS 32-1970B, you cannot be directly or indirectly compensated for those prescriptions.
Okay.
Thank you. So the representative for Preferred Prescriptions Pharmacy, you have a Erwin Wiseman, MD, listed as a partner and managing partner. I'd like you to make a statement and address that as well, please.
So Irv is an owner in the business venture. He does not see patients, nor does he write prescriptions to the pharmacy or anything like that. In the past, for other states that have had the concern, we've been able to provide an affidavit stating that, and we've handled it in other ways as well. But just for the record, he will not be sending any prescriptions directly to the pharmacy or have any involvement of where a referral issue is present.
Okay, thank you. And did you say you would be willing to do that, or have you already done that? Sent that affidavit?
I would be. We have done that for other non-resident licensure. We'd be more than happy to do that for you as well.
Okay, thank you. Board members?
Yeah, consistent with other cases, then if they're willing to provide the affidavit or send the letter, I'm satisfied that we can proceed with approving this permit application.
I have a motion by Mr. Solari. Do I have a second?
Second.
And I have a second. All those in favor?
Aye.
Aye. Any opposed? Okay, board staff will be in contact with you and looking for that communication. Thank you.
Thank you very much.
Just checking back, is a Don Adine Hayden present? I'm sorry if we did. Yes, we did. Thank you. Okay, looking at 20D, Tobor H. Ugabosu.
Hello.
Hi there. Good afternoon.
Hello.
And welcome to the meeting. If you would please state your name for the record.
Good afternoon. My name is Tobore Harrison Ubosu.
Okay, welcome.
I'm a pharmacist. Yep, I'm a pharmacist in the state of Michigan. I have been licensed, I want to say, since 2014 in the state of Arizona. I've never practiced in Arizona, but I do have a license out in your state. I got on probation with the state of Michigan, a 6-month probation, which has been completed. All terms and everything they asked of me as far as that probation was concerned has been completed. It should have been completed in October of this year. However, with the COVID restrictions in the state of Michigan, one of the issues, they needed 2 inspections at my pharmacy locations. Somehow we got lost in the shuffle of the multitude of inspections in the state of Michigan. So that did not occur till early November. And then after that inspection was completed, that probation was closed out. And I have notification from the state of Michigan that all terms of that probation have been met.
Okay, thank you. Jennifer or Elizabeth, do we have the terms of completion? I don't quite remember if we have the terms of completion of this Michigan consent.
Okay, so I'm sorry, can I interrupt?
Let's give them a chance to answer just real quick, and then I'll come right back to you, okay?
All right, sir.
I don't think so. If you look at page 2480, that date is just March 12th, 2020, so I'm not sure.
Mr. Ugaboso, did you say, can you confirm that you have completion, and is that what I see right there?
Yes, sir. This is what I have. So what happened is, because my license expired in October with Arizona, it was my hope that the end of the probation was supposed to be the 13th of October, Michigan, right? But I hadn't had the second inspection that was part of the agreement. I contacted the state of Michigan and let them know you guys haven't come out for the second inspection. And they apologized to me that this was due to some COVID mix-up. They're not going to be able to come out till early November. So I had to do the application with you guys without having this information. Then once this information was done and completed, obviously I'd already sent the rest of it out to you. I can send this as a follow-up also.
We haven't received that information yet.
No, I just got it once the second inspection was completed, middle of November. And I can send it, I believe. I'm in communication with a Miss Jennifer Mitchell. I can forward it to her email.
And what were the results of that inspection? Was it satisfactory?
Yes, so I can read it to you. Dear Mr. Ubosu, file number 53-18-153379, and license number 53-02-032536. Dear Mr. Ubosi, you've complied with the terms of the Board of Pharmacy Disciplinary Subcommittee's consent order dated March 12, 2020. Effective November 17, 2020, you're discharged from probation. Please be advised that in accordance with state law, this disciplinary action will remain a permanent part of your license history. That's from the Bureau of Professional Licenses, Enforcement Division, Compliance Section of LARA with the State of Michigan Board of Pharmacy.
Okay, thank you for that. Appreciate that. Board members, what are your questions?
Mr. Leib, I have a suggestion. I would make a motion that we approve Mr. Ugaboso's license renewal pending staff's review of the dismissal of and completion of his discipline in Michigan. If they find it satisfactory, to go ahead and allow the renewal.
Ms. Walmsley, I might add to that proof of satisfactory inspection from the last board inspection as well.
I'm willing to amend that. Thank you.
Others?
And I have all of the above to send to Ms. Mitchell, as you guys have stated.
Okay. Board members, any other discussion?
Mr. President, why does he want a license in Arizona? Is he staying in Michigan or moving here?
I live in Michigan. In the past, I had thought about moving to a warmer climate, and I got a license in 2 other states, Georgia and Arizona. I only visited Arizona for the first time, actually, for a funeral a couple years ago. Never been before. I know it's warm, originally from Africa, and a similar climate to where I'm originally from. That was solely the reason. But I do practice, and I'm still in work here in Michigan.
So you don't have a job here in Arizona to move to. You're just, if that's what your decision is, you want to be licensed so you can come here. Is that correct?
Right. Yes, sir.
Okay. Thank you.
Yes, sir.
Mr. President, I was happy with Ms. Walmsley's motion. I'm willing to second that.
Okay, thank you. I have a motion and I have a second. Any other discussion before a vote? Okay, will that need a roll call? Okay, all those in favor?
Aye.
Aye. Any opposed?
Aye.
Okay, thank you for your time today.
Thank you very much, gentlemen and ladies.
Thank you. 20E, Gavin Charles Ingalls, and I believe we're going to do the hearing first. That's my direction, to do the hearing and then come back to this application. Board members, do you have any questions or concerns on that direction?
And for 20E and 20F, we're requesting those be addressed tomorrow.
Okay. Okay, that takes us to 21A. We will push through till noon. It's 11:26. We'll pick up at 21, license applications requiring board review. 21A, Taylor Watson, technician license applicant. If I could ask the compliance officer that brought this forward to give a brief comment on it, and then board, we can go into discussion.
I can give a brief overview. This is for Taylor Watson. She applied for a technician license. She did disclose that she had a criminal conviction for cocaine. It was later dismissed. This occurred in 2016.
Okay. board members, just preliminarily, my concerns are the type of substance that was found, and there was evidence that it was more than just, there was residue and paraphernalia in 2 different places in the reading. So it was my concern on that. I know this was her first infraction. This was, when was this, Dr. Dodge? Was this in 2016?
2016, and it looks like she was arrested while driving. So I think she was charged with the DUI as well. I'm guessing she pled down to the cocaine.
So my concern is the type of substance it is, and does that, you know, a DUI of alcohol, is that looked at differently than a DUI of cocaine? And in my opinion, in the profession that we're in, it does. And I would be leaning towards hearing conversation from you on, is a substance use evaluation something that we should go down with this applicant? It did happen in 2016, so there's been some water under the bridge, but I'm going through the reading in here, I can't say 100% that there is a, I shouldn't be concerned about that.
May I ask a couple questions, sir?
Absolutely.
Do we know if she's licensed in another state? She's applying for a tech license, not a tech trainee, which makes me think she has other licenses or at least been working as a tech trainee somewhere. In some ways, I'd like to talk to her and ask her some questions and get a feel from her after meeting her. And so I would like to postpone this till she can actually appear.
I don't think that's a bad idea, Mr. Solari. Other board members?
Maybe we could consider doing an evaluation from the time now and the time that she appears.
Mr. President, it has been 4 years since this took place.
True.
That's what I was going to say. This has been 4 years. I don't know if this is the only offense she's had in 4 years. She's been working fine and hasn't had a problem. Maybe evaluation is not necessary. But if she's had other issues or if she's not able to work, then we would go down a different path. That's why I'd like to meet her and talk to her.
Mm-hmm. Makes sense.
And she did self-disclose as well. So it's not like she wasn't truthful on the application either.
Mr. President, is there a chance is there a reason she's not here, or can we get her?
She did notify us. I apologize. She did notify us that she was unable to appear today. She does understand that this may be tabled until the February meeting.
Is there a place of employment that's listed that we know of?
Hey, I think, Mo, you got the beginnings of a motion to table until February when we hear from her. I think that's fair.
Okay, let me make that an official motion then. I'd like to make a motion to table this discussion till February when we can meet her.
I'll second that. Any other discussion before a vote? Okay, all those in favor?
Aye.
Aye. Any opposed?
Okay, thank you.
Thank you. 21B, Lisa Ann Span.
Sorry, did you say Lisa Lee or Lisa?
No, Lisa Span.
Lisa Span. Mr. President, I don't see Lisa Span in our meeting.
Okay. This did take place in 1998. I don't see any other infractions on her record since then. Was this disclosed?
Yes.
Yes.
Okay, so it was disclosed as well. I'm leaning on this situation to a grant application, but I'd like to entertain board member discussion prior to that.
I agree with you, Mr. President. She has a valid fingerprint card. The incident was greater than 20 years ago. She did disclose. So I am also in favor of approving with an advisory letter to file.
And Mr. Solari, tell me about the purpose of the advisory letter.
Just so if it happens again, while as a pharmacy technician, she does anything, we have the previous record or a letter to file that we can rely on or go back to. It's a non-disciplinary.
Other board members?
Mr. President, I don't see any reason for an advisory letter. This was 20 plus years ago. I think we should move this to give it to her.
I agree with Mr. Minkus.
Mr. Solari, I understand your point too, but I do agree with that. It may not be necessary, especially because it was disclosed. And if something did take place, she would be bound to report that to us as well, and we would see the trail.
That's fine. I'm okay with that.
Okay, did you have the beginning of a motion?
May I ask?
Sure. I'm happy to make a motion to approve her application.
Second.
I have a motion by Mr. Solari and a second by Ruben. Further conversation and question by Mr. Tong.
Would she be required to disclose when she applies for the actual technician license? Because this is for training. It's a trainee license. So she should be aware that she needs to disclose it when she's applying for the technician license?
Yes, she will. She will have to disclose this action on any license she applies for now or going forward.
So as long as she's aware of it, I mean, related to.
And she disclosed on this one, so I think she is aware of that.
Thank you.
Okay, all of those in favor?
Aye.
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 Any opposed? Okay, thank you. 21C, John Rector.
Yes, good morning.
Good morning. Would you please state your name for the record?
My name's John Rector.
Okay, welcome to the board meeting.
Thank you.
Mr. Rector, you are applying for a technician application. Can you tell us a little bit about your request before us today?
Yeah, so I am applying for my technician license, and I got an email from Sharon stating that one of my DUI convictions was not on my trainee application. So I definitely appreciate the opportunity to come and speak on that today. It was a mistake. I honestly had no motivation to hide that from the board. I had been hired at CVS Specialty when I applied for my trainee license, and they knew about both of those convictions. They were on my background check. They didn't seem like it was a problem, so I wouldn't have felt like I had anything to worry about. And I also vaguely remember at the time, like before even getting into pharmacy, because that was my first pharmacy job, seeing how DUIs were viewed in pharmacy. And it seemed to me like there was more of a concern on theft and drug charges, specifically with like prescription drugs. So, I mean, yeah, I definitely I had no reason to do that on purpose.
Okay, thank you. Can you answer a question for me? How many DUIs do you have on record?
2.
2. And what is the time span of those 2 DUIs? When was the first one and when was the last one?
So the first one was in 2015 and my second was July 2016.
Okay. Members, discussion?
Mr. President.
Cedar. Sorry, and I need to recuse myself from this one. I'm sorry.
That's okay, thank you. Mr. Minkus?
You haven't had any issues since 16 then, is that correct?
That is correct.
Okay. And you quit drinking?
Yes, I have. I have.
All right. Thank you.
And Ms. Lehan, you're recused because of Mr. Rector's association with CVS?
Correct.
Okay.
What does our grid suggest that we do?
If you've had 2 within the last 5 years, evaluation. But looking at this one, he has had the 2. He's coming up on the 6th year of it. So I'm not entirely sold we have to go that route on looking at the timing and looking that he disclosed the first one, didn't disclose the second one. But in the cases where we've had a partial disclosure, we've been more understanding to applicants than we have if they completely said no. They have not had any problems.
Yeah.
Ms. Snare, what was your opinion, if you don't mind me putting you on the spot?
No, I don't mind. I just was curious what our guideline kind of was on it, but I agree with your reasoning that you just gave. I see that do you currently have ignition? No, you had to have an ignition.
Yeah, for 6 months.
I was thinking a $250 fine for not failure to disclose. I was kind of thinking it initially.
But it was a partial disclosure. So
it's just
how we handled
did it once
how
and
we
not
handled,
another time.
yeah, how we handled partial disclosures in the past.
If they've disclosed themselves, then we've kind of been lenient. But he did not disclose the second DUI. Isn't that correct?
I didn't disclose it on my trainee application. They're both on this application for my actual technician license.
Mr. Richter, why do you want to be a pharmacy technician?
I really enjoy what I do. Especially with working in specialty meds as a patient, a specialty patient, it allows me just to be more involved and more understanding and more empathetic about what's going on. And I've seen a lot more success in pharmacy than I have seen in other jobs that I've tried. So
thank you. Board members, any other questions from Mr. Rector? Board staff, any clarification needed?
Mr. President, Mr. Rector has made a good professional appearance here. He's disclosed his stuff to the best of his ability. I'm okay with approving this application. I'll make
Second
a
that.
motion to that effect.
And I'll second that. So I have a motion and a second. Any other discussion?
Aye.
Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, thank you for your time today, Mr. Rector.
thank you so much. That's amazing news. Thank you, honestly.
Thank you. 21D, Emma Catherine Elder.
I would also like to note my recusal for this one. This is Cedar as well, due to my employer.
Thank you, Cedar.
Hello, sorry, I was on mute.
Hi there. Welcome to the meeting. If you'd state your name for the record, please.
My name is Emma Elder.
Okay. Emma, you are in front of us today for a trainee application. Can you tell us a little bit about your request today?
Yes, so I really wanted a chance to meet with you guys about my trainee application. There were some issues along the process because I did have some drug charges from when I was 18 years old. I had possession of marijuana. I had a gram of marijuana, and I just wanted a chance to be able to let you guys meet me and answer any questions you might have for me, and hope that I can convince you that I'm a good candidate for the pharmacy.
Thank you for that statement. You disclosed a misdemeanor charge, but you left off kind of the larger charge. Tell me what your your thought process was there. What do you think happened? It was the felony that was not disclosed.
I thought I did disclose the felonies. So that's a little confusing to me. I thought I did disclose them, and I've been talking to Sharon since about August now, and we've gone back and forth. I've sent her my complete full record from DPS. I've sent her my list of incidents with the Gilbert PD. I've sent her even, she needed the paper from the Superior Court that says no records found, and I even went to go find that for her to show her that I didn't have any record with the Superior Court. So I do apologize if it wasn't included in my first application. I promise I really did think that I included it because I had no intention of hiding it. Obviously, I know you guys do your research on the back end, so there would be no point in trying to hide something like that. But I have turned in my complete record, and I've been speaking with her on it for months now. So I feel like I've been very transparent, and I'm willing to answer any questions you guys have on it.
Thank you. Board members?
Mr. President, I'd like to, Emma, how old are you now?
I'm 21, going to be 22 very soon.
Okay, so this was 3 or 4 years ago that all this took place?
Mm-hmm.
Mr. President?
Yes.
Ms. Elder, you have a cosmetology license, is that correct?
Yeah, I have an aesthetics license.
What do you do with that, or how do you want to transition into pharmacy? Explain that process for me.
So I first, was really interested in aesthetics. Actually, originally growing up, I really wanted to be a nurse. That was my goal that I had in mind. And I went to aesthetics because I'm also very interested in skincare and everything along those lines. And I eventually wanted to pair my RN with my aesthetics license and be a medical esthetician. Because of my charges, I was on track. I was about to go into the nursing program. I had finished all my prerequisites and was about to turn in my application when I was pulled over by the cops, and all of that went down, and that kind of was derailed. So I had to find out, what is my plan B? What else do I want to do? And I had a friend through, sorry if I start crying, this is just super emotional for me. But I had a friend through cosmetology that worked with CVS for 5 years as a tech, and she was just talking to me one day, and I was really just I don't know what my plan B is. It's been 3 years, and I don't know anything else I'm passionate about other than nursing, and that's not going to happen for me. And she suggested, I think you would really enjoy the pharmacy because I did it for 5 years and I absolutely loved it there. So that's what got me into that.
Okay, thank you.
So is your cosmetology license still active? Did you get any discipline on that from these charges?
No, I didn't. It's still active. I need to renew it in January, but it is still active. I was actually in cosmetology, or was I? Yes, I was in cosmetology school at the time of the incident. And when I had gone and applied for my application, I hadn't yet gone to court for everything. So I think that's maybe why I didn't have any complications there. I'm not too sure, but it is still active.
But you haven't disclosed this information to them, your arrests.
That was 3 years ago, so I'm not exactly sure. Yeah, I'm not exactly sure. I do apologize.
Mr. Slary, I don't know if it is required in that discipline or not either. Exactly.
Agree.
Okay. Other board members?
Ms. Elder, how old were you when you were arrested?
I was 18. I had just turned 18.
I'm not clear why the Superior Court filed the documentation saying that there are no records relating to Miss Alder?
So that was the issue that we were having for a really long time. We kept running into dead ends, but we knew that the records had to be there somewhere. So what we were told at the Superior Court was that basically with felony charges, you know, they have 7 years to press those charges. So my charges are kind of in this limbo phase at the moment. If I'm not sure the title of the person who decides this, but the person who goes through the records and pulls them and says, okay, we want to go ahead and press these charges, he hasn't yet pressed those charges against me, so it shows no record. Once he pressed those charges, it would pop up in their system. However, I did speak to a couple people at the Superior Record, and they looked at my file from DPS, and they said with something as small as this, in the grand scheme of like all the felony charges they deal with, if they haven't pressed the charges yet, especially with the new laws coming out, they don't feel that they will be pressed. But I mean, that's just their opinion on that.
So you've been arrested but not charged.
For those two, I was charged for the 2 misdemeanor. Well, technically 1, because one of them was dismissed, but the misdemeanor I did go to court for. I did see that through the end. I paid all my fees, took all my classes, and that has recently been set aside by the court.
And this happened in 2017, right?
Mm-hmm. Yes, ma'am.
All of the events.
Yeah, it
both
was
the
just
felony and the misdemeanor.
Yes, it was one event.
Do you have a plan for where you're going to get your training?
Yes, so I did get a job at CVS. Right now I'm just a shift supervisor. But they would like to move me into the pharmacy as soon as I get my trainee license, and then, you know, go from there.
Okay, good. Thank you.
Mm-hmm.
Mr. President, if I can, I'd make the motion to go ahead and let her get her technician training license.
Okay, thank you.
Goodman, second.
I have a motion. I have a second. Any other discussion before a vote?
Would you like to put if she is charged, she may not be aware of the statutory requirement that would require her to do that.
Ms. Galvin, you cut out. I only heard half of what you said.
As part of the motion, do you want to remind Ms. Elder that she has a statutory obligation to notify this board within 10 business days if she is charged in the future?
Yeah, I think that'd be a great addition to put in there. Absolutely.
I concur.
Okay, so I have an amended motion and amended second. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you for your time today.
Thank you so much for meeting with me.
Thank you.
Mm-hmm.
Luck.
Okay, so that takes us through 21. Am I correct, team?
That is correct.
Why don't we recess for lunch and return at, I will defer to board staff. Are there any appointments pending, specific times that we need to be back for besides 1 o'clock?
No, I think we're good to go, Mr. President.
Okay, we'll come back together at 1 o'clock and enjoy your break.
Hello.
Thank you.
Thank you. Hey, guys.
Hello.
Hello.
Howdy.
Okay, welcome back, everybody. We will pick up 22A, but before we do, I will ask Dr. Gandhi to do a roll call.
Okay, Mr. Solari,
Ready to go.
Mr. Dang,
At your service.
Mr. Minkus, Mr. Minkus. Come back, Mr. Leba,
Here.
Ms. Lahan,
Present.
Ms. Walmsley,
Present.
Mr. Tom,
Here.
Mr. Goodman,
Here.
Ms. Nair,
Here.
and Mr. Minkus.
I'm here.
All right, there we go. They're all accounted for, Mr. President.
Okay, thank you. Picking up.
Joe, you're muted.
Sorry, it keeps doing that. My apologies. Picking up on tab 22, license applications requiring board review. 22A, Melissa A. Schmidt, pharmacist license applicant. Ms. Schmidt, are you present?
Yes, I am.
Okay, welcome to the board meeting. Thank you for joining us. If you'd state your name for the record, please.
Melissa Schmidt.
Okay, you are before us with a request for reciprocity application for your license. Tell us a little bit about your request today.
I'm a remote pharmacist. I live in New York, and my company asked me to get licensed in a couple additional states, one of which was Arizona.
Okay.
And when I filled out my application, well, let me just backstory. In 2013, I unexpectedly lost 2 members of my family, and I was pregnant at the time, and my habit had always been to throw myself into my work. So what I did was I knew people on the board, and they're like, oh, if you voluntarily surrender, they make the therapist available to you. So I did that. And I had no idea that, because it was a confidential agreement, because it was voluntary, it was not, substance related or anything. They reported to Connecticut, which I didn't know until the summer when I filled out the application. Had I known that New York reported to Connecticut, I would have obviously disclosed that. But I thought I had a confidential, agreement with New York State. So that's why I did not. So I apologize I wasn't trying to misrepresent myself or anything like that.
Okay, thank you. And your part of your agreement had probation tied to it. And have you finished with all that probation and the terms of that consent all satisfactory?
Yes. In 2000, I went back to work after like 9 months, but then the probation lasted for like a while, like a long time, like 24 months or something.
Okay. And Ms. Schmidt, my question here, you do not have to answer if there's anything that is personal information in here about medications. It early in your statement did not include medications. Am I correct?
Yes. It was just, I just needed some mental health, and I wanted to get my head on straight for my child that was coming, myself and my patients.
Okay, thank you. With that, board members, questions for Ms. Schmidt?
I'm unclear, Mr. President, if this was disciplinary or non-disciplinary. It appears that it was non-disciplinary. Am I correct with the Connecticut reporting?
I don't know, Mr. Solari, and I would defer that because there was probation tied to it. And typically when probation is tied to something, there is a disciplinary order, but I will hand that over for board staff.
It also says that she was, from my understanding, and correct me if I'm wrong, Melissa, that you were summarily suspended?
I was not suspended.
You were not suspended. And what were the terms of your probation? Was it to stay in an assistance program?
No, I was just seeing a counselor for grief therapy, and I guess it's part of the procedure when you voluntarily surrender, because most times it's due to other issues. So it was part of it, and I didn't have a problem with doing it. It was, I sent them they had random drug tests a couple times, and I would send stuff to my therapist. After I completed the grief counseling, my therapist sent them a note saying that, like, I'm not a danger to myself or the public or anything.
Sure. And Ms. Schmidt, I do acknowledge your hard times that you went through, and thanks for sharing that. In having said that, was this in 2013 that you went through this period of rough time?
It was January or February of 13. I don't
Okay.
remember.
And since the period of your reinstatement of your license, you've been in good standing and no disciplinary or no investigations on your license?
I've been a pharmacist since 1998. I've never had any disciplinary action. I just had this incident, and it was, again, just for my own mental health.
Okay. Board members,
Ms. Dodge, it does, in the agreement, Ms. Dodge, it does confirm what she said, that she was part of the New York assistance program.
That's what I had read too.
That's what's in the agreement that she signed.
So it was not disclosed, though, on your application. Is that correct?
It was not disclosed because I did not know that New York reported to Connecticut, and then Connecticut said, I don't know if it was disciplinary action or anything, but they reported something that came out. I didn't know about it until this summer when I applied for these additional licenses.
So Ms. Schmidt, Ms. Galvin, I'm sorry.
There's just nothing in the agreement that indicates it was confidential.
Oh, that's what I thought it was, because it was, voluntary.
That doesn't make it confidential.
No, but I mean, it was a long time ago, but I swear I read it, but if it doesn't say it, doesn't say it.
Mr. President, also, I think I want to expand on Ms. Elizabeth Dodge's comments. On page 2755, it does state that the summary suspension will be effective on a date of notice. So there was some summary suspension action taken against this person.
I apologize, Kim. I think it was actually saying, and that was my fault, was that it may result in that. But on page 2755, it does say, it is what Jean Galvin was talking about. It talks about her participation in the professional assistance program.
Ms. Schmidt?
Yes.
I might make a suggestion that I think what I'm hearing, there are some unanswered questions. Would you be open to going to a executive session where the public is not in the meeting room and the board members are, and we could ask you questions that you might feel more comfortable answering?
Sure. I mean, I would be comfortable answering any questions in this format also.
Yeah, let's go into an executive session. I'll make that my motion so we can talk confidentially with you, and you'll come with us in that room as well.
Okay.
I'll second your motion.
Okay. All those in favor?
Aye.
Aye.
Any opposed? Okay, so Ms. Schmidt, you'll be sent a room invite. It'll pop up on your screen, and then we'll.
Okay.
Okay. We're good to go, Cam?
I think so. Lynn, if you can close out the breakout room so that anybody that's left is put back in the main room.
The executive session is closed.
Thank you.
Everybody should be back.
Thank you.
Thank you.
Okay, welcome back. I'll open it up for discussion. Board members?
Mr. President, if I may. Ms. Schmidt, why do you want an Arizona license? You're on mute.
The company I work for, I work from home. I work remotely, and they asked me to get a couple of additional licenses because they're getting new contracts, I guess. I mostly deal with long-term care pharmacies, and they asked me to get Texas, Pennsylvania, and Arizona. So that's what I'm doing, or trying to do.
Thank you.
Have you been granted a license by those other states?
In Pennsylvania, had the law exam last week, but otherwise I'm good to go otherwise. And Texas, they're still reviewing. They said they have COVID delays, and so I'm hoping to hear soon.
Are we able to get more information that gives more context from New York? From their board?
I think Connecticut was where, let me see.
Oh, okay, I thought it was New York when it.
Connecticut was based on New York,
Okay,
on the New York surrender.
okay.
I don't know if we've requested any documentation from either of those states, like your investigative report.
So we're able to request just maybe to give us more context.
And I don't know if staff has had the opportunity to do that, or if they were rejected. I don't know if the states responded.
We have not requested that.
Yeah, and so that might be one option.
That would be where I'm leaning.
So I'm ready to make a motion that we table this and reach out to New York Board of Pharmacy to get more context, more information, anything they can provide to give us background on this.
Okay.
Ms. Snare, would you include in your motion that the staff also contact Connecticut in case Connecticut has New York's information? And
yes, I would amend my motion to include Connecticut.
Thank you, Ms. Snare. I have a motion. Do I have a second?
Second.
A second by Ms. Walmsley. All those in favor?
Aye.
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 Any opposed? Okay, thank you, Ms. Schmidt. The board staff will be in touch with you.
Okay, thank you.
Thank you. 22B, Luciana Pulu, technician trainee license applicant.
Mr. President, I do not see her on our meeting.
Okay. So board members looking at this, it is my opinion that this one definitely falls into 2 DUIs within a 5-year time span and could qualify for the substance use evaluation. And then we make a decision after that. And I'll open it up for other questions or ideas.
That's what my thought was too. I agree with you.
I agree as well.
Okay, having said that, I will make that my motion.
Second.
Before a vote, any other discussion? Okay, all those in favor?
Aye.
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 Any opposed? Okay, thank you.
Do we need to add
A
that?
is vacant.
Mr. Labor, should we add that if he doesn't sign, is that just implied that?
This would be an order, so there's no requirement of a signature. You could add if she doesn't comply with the interim order, it would go to formal hearing. If you want to make that a second motion.
I would like to make that a second motion.
I'm sorry, Mr. President, since this is an application, if she doesn't comply with the order, can they just deny the application?
Yes, be denied.
All right.
You're right.
If it doesn't comply with order, then deny application. Okay.
Yes.
So is that a second, or I just need to amend?
I would do we haven't voted, have we? No, so go ahead and amend it.
Well, I didn't make I just seconded it, right?
Okay, I will amend my motion, and I have a amended second by Ms. Snare.
Yeah, I'll second.
All those in favor?
Aye.
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 Any
Gee,
opposed?
because this has the possibility of denial, should this be a roll call?
Yes.
Okay, roll call, Dr. Gandhi.
All right, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leva,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Snare.
Aye.
Tab 24.
I can't hear you.
Joe, you're muted.
Can you hear me now?
Yes.
Okay, 24A 20-0307, Ryan Allen Manley. Mr. Manley.
Do not see him in our meeting, Mr. President.
Okay.
So at this point, can we proceed to hearing? Since we would typically put that in our order if they didn't sign the consent.
You may move it to formal hearing for the underlying failure to pay, or he didn't accept the offer. I don't recall what the facts are.
I don't think he responded to the subpoena or the consent agreement.
Not sign the consent agreement.
Was it a failure to
Consent
disclose?
agreement to sign. It says in the consent agreement, and I don't know what page it's on, but if they did not sign, not complying will be considered voluntarily.
It says it be forwarded to a hearing.
Here is a failure to disclose. So if it's
Number
a failure to disclose, we can send it to formal hearing.
Gene, on page 2846.
That would have been the terms if he had accepted it.
I see.
Correct.
Okay, yeah. Thank you.
I make a motion to proceed to hearing.
Have a motion. Do I have a second?
Second.
A second by Dr. Dang. All those in favor?
Aye.
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 Any opposed?
Nay.
Noting one nay by Mr. Minkus. Moving on to 24B, taking two together, 19-0446 and 20-0471. And I am noting recusal, and I'll hand it over.
Let's see. We have two matters before us. Cases 19-0446 and case 20-0471 for Miss Lisa Lee. Is Miss Lisa Lee available?
Yes, I am. Can you hear me?
Yes, I can. Thank you, Miss Lee. Can you please state your name
Madam
for the
Vice
record?
President, Madam Vice President, sorry for the interruption. Just for the public, at the previous meeting, I had informed the board members and the public that I know Ms. Lee in the past. I have not talked to her for years, but my decision would not affect the case whatsoever. So I don't know, should I continue to be recused from this particular case or should I stay on?
Thank you, Mr. Dang. Ms. Galvin, Mr. Hargraves, do you have advice for Mr. Dang?
Mr. Dang, you have stated on the record that your previous relationship or acquaintance of Ms. Lee will not impact your decision.
Correct.
Then you are free to continue to adjudicate the cases.
Okay, thank you.
Thank you, Mr. Dang. Ms. Lee, can you please state your name for the record?
Yes. Can you see me on the video?
I cannot, no.
Okay, so I don't know how to get it to work because I've been trying to get it to work and it's not allowing me to put on the video. So is this okay? Are you guys okay with this?
There's no reason why you can't continue without the video. Go ahead.
My name is Lisa Lee. I'm a pharmacist and my case is 19-0446.
Thank you. Dr. Gandhi, Ms. Jennifer, can somebody give us a brief summary of the two issues before us today?
Certainly, Madam Chair. Some time ago, the board had issued an evaluation for fitness of duty that Ms. Lee was supposed to perform using the evaluators that we have approved. Ms. Lee was guided to use those. It looks like she's used another person to do her evaluation for fitness of duty. We do have that evaluation in the board book for your review. The second matter we're discussing here is, of course, the CEs that Ms. Lee was supposed to have done and supplied us the information. I did receive an email from Ms. Lee this morning, indicated she did do 30 hours of CE for this last renewal cycle, and that it would take about another week for NABP to upload that in the system. But that email came to me this morning, so I haven't had a chance to forward it to you guys, but that's the information I have.
Thank you. Thank you. Board members, any questions for Mr. Gandhi before we allow a statement by Ms. Lee? Go ahead, Ms. Lee. You've heard the summary by
Lori, you have frozen.
Can you hear us, Lori? Okay. Looks like she's going to log back on. Mr. Gandhi, in the letter that you received, was it the full 30 CEs accounted for, or it's just a statement saying that she had done them. We don't know if that's verified or not at this point.
That's correct. I don't,
I think Miss Mitchell was able to pull that for us, Cam.
she was, okay.
We were able to verify she did 30 CEs between December 7th and December 8th.
Sorry about that. My internet died there.
Can I say something about that? I had completed all the CEs way before that, but I just waited those 2 days and put those to take all the exams at the same time, to record everything at the same time. But it was not done just those 2 days. But that's why I had completed them, and then I waited until those few days prior to the meeting before I inputted them into the system. So that's what it showed.
So were the CEs late?
Sorry?
Were they, I'm asking board staff if the CEs were late.
Yes, they were. And in fact, I don't think we were, and Jennifer, if you can correct me if I'm wrong, that we have not seen any CEs since 2016.
That's correct. September 2016 was the last CE in the CPA monitor.
So she's deficient for 2 renewal periods.
Correct.
I because I had received a letter from Jennifer. I don't know her last name, Jennifer Mitchell, I think, telling me that because I had already mailed in and paid for my renewal for October the 30th of 2020, she said that can I send her proof that I completed the 30 required CEs for that period? And I said that I'm sorry I was not able to complete the CEs because I was in the hospital and I was sick, and then and all that kind of issue, and I had to do rehab and rehabilitation and all that kind of stuff, so that I was not able to complete all the 30 CEs before the renewal period. So then I'm just, trying to get this done, at least, trying to do something before this meeting to get it done. That's why I completed all the CEs, at least prior to this meeting for that period. It was an effort to show you guys that, I do want to renew my license and have it in good standing.
So board members, since we have 2 separate issues with 2 open complaints, I think probably it would be helpful to take them one at a time. The first issue was the issue related to the evaluation from the prior meeting. Ms. Lee has completed an evaluation. Granted, it was not by one of our board approved evaluators and did not follow our advice from the last meeting. Any suggestions on how we handle that matter at this point in time?
Lori, if I can, we told her what to do, to go to one of our providers. She elected to go to her own provider. It seems like she has a problem in just following the rules inside the bookmarks that we've set for her. And so this evaluation, as far as I'm concerned, is useless. If she has to go to one of our providers and do it there, and then we can review it. If she doesn't want to follow our rules and follow the suggestions that we've made, then none of this has any bearing on anything, in my opinion. So I want her to start following the rules according to the way we dictate them and do it that way. End of story as far as I'm concerned. And excuses, I'm just tired of listening, to be honest with you. That's my opinion.
Mr. Solari, did you have a comment there? Looks like you're trying to speak.
Yes, there's also a problem with precedence. If we relax the rules for her and accept her evaluator, then later on we're going to have to make an exception for anybody who wants to submit any evaluator they want. So I agree with Mr. Minkus. It's better to stick with our rules and stick with our evaluators just to be consistent. Then we don't have to deal with this issue in the future when somebody can't go to an evaluator that we approve.
I don't disagree with you per se, but I do think this case is perhaps a little bit different. I'd like to make a suggestion that we go to executive session for the purpose of legal advice.
I'll second that.
All those in favor?
Aye.
Aye. Any opposed? Ms. Lee, we'll be right back. We are going to confer with our legal counsel on this matter, and we'll be back to open session after we get that advice.
Yes, thank you.
All right, Dr. Gandhi, do we have everybody accounted for from executive session?
The room
Yes,
is
we did.
closed.
Okay, and the room's closed out?
Room is closed out, yes.
Okay, thank you. All right, board members, so back to our discussion related to the prior complaint and the request for the evaluation. So again, I guess to recap the issue, so we ordered for Ms. Lee to complete a fitness for duty evaluation by one of our providers. Ms. Lee did not comply with that particular order to the letter of the requirement. She had another qualified provider complete the evaluation, which she submitted. So suggestions on how we handle this at this point.
If we're recognizing the individual, the psychologist who performed the evaluation, this psychologist did not find any reason, apparently declared her fit for duty. So at this point, I think we can dismiss the complaint and let her return to practice. I don't see anything else we can do.
The one concern that I have on top of that, so, and I guess just for the record, so I think that the difference here with her using a board approved evaluator for this particular circumstance versus some of our other evaluations, the difference is this was not a substance use evaluation. This was a fitness for duty evaluation. So this wouldn't necessarily have been tied to any of the other monitoring requirements per se that we would have with our normal substance use evaluations and participation. So just to kind of clarify the thought process, I think that we all kind of have at this point in time. I'm in agreement with you. I'm comfortable based on the evaluation that we have. It was completed by an appropriately licensed physician in that area to accept that and say that she's fit for duty. Although I do have concerns that she did not comply with our order, and we directly told her what we wanted, and she still did not directly comply. She also asked Dr. Gandhi for clarification, and he provided the same direction. So I would be comfortable with your recommendation to accept it and allow her to return, but to place an advisory letter on her license for failure to comply with this particular order as well. Any additional discussion, board members?
Ms. Walmsley, can I just double check with Ms. Lee? So was she charged by the Chandler Police Department?
Sorry, ma'am. Charged with what? With what?
What happened at the doctor's office? Were you, when you were arrested?
Disorderly conduct or something?
And yeah, unfortunately, I was charged, but I had a lawyer, and they fought the case, and it was clear and everything, and so it's been taken off of my record, and I don't and I'm basically I'm clear of all wrongdoing.
I guess my only concern with that was that I thought that initially we had a failure to report the charge. I'm researching that right now.
Well, I had explained to you guys the reason why. At that time, I was just so distraught. I didn't think about that, and that was like, I just didn't think about that. And unfortunately, I should have done that, but because I thought that I was in the right, and that nothing would come to this point. And so that's why I didn't think of reporting it and it was not even in my thought process at that time, because I was so distraught and I had to deal with so many issues that came at me. So I do apologize about that problem. But at the last meeting, I had explained it to the board already, and I thought that you guys understood the reason why I did not report it at that time.
Correct me if I'm wrong, staff. Ms. Lee, hang on just 1 second. Correct me if I'm wrong, but I believe the complaint was opened by the physician that she was unfit to be for duty. It was the purpose of the complaint, just to make sure that we're all looking at it from the same perspective.
That's correct. And when we started to investigate that, that's when we found out as well that she had been charged. the physician's office had filed a allegation against her.
Yeah, and that office was probably the office that discriminated against me and called the cops on me for no reason. I was just talking, and they took my money. They wouldn't treat me as a patient, and they discriminated against me severely. So I was just speaking my mind and defending myself. I did not touch even a hair on anybody's head or anything. I just talked, and they got me arrested for just talking and asserting my First Amendment right.
And Ms. Dodge, I don't believe that we have documentation showing the adjudication of the charge.
Yeah, you do. I sent it all to you already.
I can confirm that, Jean.
Pardon me?
I will confirm that. I'm looking right now.
And I had also filed a complaint against that doctor's office, ma'am.
Miss Lee, let the staff take a quick look at the additional documentation. Board members, any additional questions while Ms. Dodge is looking for that on this particular matter?
I don't see the information in the file relating to the disposition of the criminal charge. And Ms. Dodge has checked as well and is unable to find it. It doesn't appear that it was filed, because I would know that Ms. Dodge would locate it.
And I am checking with Jennifer Mitchell just one last time to see.
I sent you guys all the records that you had requested, and I can send it again to you if you like. But it did show that I was cleared and everything of all the wrongdoing, and I completed all my requirements in order to get it cleared off my record.
So was there a conviction, Ms. Lee?
No, there was no. I don't think there was a conviction, because my lawyer fought the case, and she so the prosecutor on the other side said that if I attended a anger management class, like 6 session, and that was like the minimum that was needed, then it would be cleared off of my record, and that's what I did. And I sent you guys all the paperwork and everything already.
So that is a diversion program. So it wasn't a dismissal. She was
no, it was a dismissal. It was a dismissal for me. In order for the case to be dismissed from my record, that's what I had to do, and that's what I did. And I sent you guys all the documents and everything already. I can resend it again to you if you like.
According to the Chandler Municipal Court website, the case was disposed February 7th. Complaint dismissed on application of town attorney, the violation of disorderly conduct. So the violation date was October 4th, 2018, finally disposed February 7th, 2020. It doesn't give any indication here whether it was a deferred or if there was anything else, but either way, there were pending charges that were not disclosed under 32-3208.
I don't know what you're talking about, sir. I have to talk to my lawyer about that, because I don't know. She just sent me all the records. She said that the case has been.
Miss Lee, the board is discussing the factual information that we have. Hang tight, and then if we have any questions, we'll come back to you, please.
Okay.
Mr. Hargreaves, did you have anything else to add?
No, just according to the website, it looks like the case is concluded.
But she would have had, her requirement was to report that charge based on our requirements.
Right, there were charges that should have been reported.
Yeah. And both for 2018 and 2020, right? Because it was February of 2018. So when she renewed in 2018, she should have disclosed it. And then when she renewed in 2020, she should have disclosed it.
Well, I'm just referring to the requirement under statute to report to the board within 10 days. I don't have the application, so that I'm not familiar with.
And that's all we were referring to as well, Seth.
Mr. Solari, I think it gets a little tricky when the question says, since you last renewed your license, have you, But yeah. I would be in favor of a $250 fine, failure to disclose, for you to be able to plead down to take a class then there obviously has to be a charge to be able to take a class to get it dismissed.
So from a logistical standpoint, Ms. Walmsley noted that the original complaint did not have that in it. Do we need to open a new complaint and address the non-disclosure, or can we address that issue at the same time here and finish this thing?
Mr. Solari, that was part of the original complaint. It was all part of one. Where it kind of got derailed, so to say, was that we went down a different route, trying to do a little more investigating, with an evaluation, et cetera. So I had remembered it. It's not in the board book, but it was in there before. So it is a part of that case.
Right.
Thank you.
As far as case 19-0446, where the interim order was issued, in the factual allegations of the interim order, it did make reference to the charge and the failure to timely report under 32-208.
Okay.
Great. Okay.
Okay. So we should address that as part of this complaint as well. So I think we had a motion on the table. Does somebody want to amend their motion?
Well, I didn't make a motion. I was just for points of discussion. I was saying that I didn't see any, but I can certainly make a motion at this point that to close out complaint 19-0446, we offer a consent agreement for $250 for non-disclosure, and if it's to be payable within the standard 90 days. If not paid, we move to formal hearing.
And did we already address the advisory letter?
I'm sorry, repeat that?
Did we already address that we were going to have an advisory letter for failure to?
In addition, place an advisory letter in her file for choosing her own provider instead of following the board the board staff recommendation to go to one of the approved providers. Thank you.
The board order.
Board order. I'm sorry. Yes.
Mr. Solari, if I can just get clarification, you said within 90 days, if not paid, go to hearing. She does not accept the consent agreement. Do you want the case to go to hearing at that point?
Yes, I do.
And we do have her renewal application in front of us right now.
And the other complaint for the CE that we still need to deal with.
Yes.
So let's address the CE thing and then come back to the renewal. Is that okay?
Oh, no, I was just
ahead.
intending to that did you want to do anything if she fails to sign or decides not to sign that consent agreement with her renewal? Did you want that attached in some manner?
Okay, so another amendment, if she fails to sign or pay, we will not renew her application. Pending the outcome of the hearing.
Amend my second.
I think the motion would be if she doesn't pay or doesn't sign the consent agreement, her renewal application would be denied.
Okay, I will make a motion to that effect then. Deny the renewal.
Second.
And also offer her the administrative letter.
That's right.
Issue.
Is everyone clear on the motion related to the initial complaint related to fitness for duty and failure to report within 10 days charges?
Just one final thing. I'm sorry, Lori. Ms. Walmsley.
Okay.
Just to clarify, that would be that she would have to sign that consent agreement within the 30 days, just like the other cases?
Yes.
Okay.
Signed within 30 days, payable within 90 days. Is that acceptable?
It is to me.
Can I say something? I mean, I don't understand. Like, can I say something before you guys finalize the motion, or is that the point of this meeting?
Yes, if it's quick and if it's new information, that's late.
Yeah. I mean, I had explained to you that at the first meeting, the reason why I was not able to go with the evaluator that you guys had selected for me was because when I called them to ask about everything and get the details, I did everything that I was supposed to, but I didn't follow through with it. It was because they would not accept my insurance.
Miss Lee, I don't know that I don't think you're understanding what our motion is. Our motion is that we are going to accept your evaluation and allow you to renew your license, but we are going to issue you an advisory letter for not following our order to use our board approved physician.
I understand that, ma'am, and thank you for that. But I was just trying to explain to you the reason why I did not go with them is because I don't know. I have insurance. They wouldn't accept my insurance, and the people that you had selected was not part of my network, and I was not working at that time. So how could I have $4,000 to pay that?
Miss Lee, I appreciate that. This doesn't appear to be new information, so we're going to go ahead and go on and vote on this matter at this point in time.
Okay, ma'am. Thank you.
Is it roll call?
Yes.
It is. Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Hey,
Mr. Leba is recused, Ms. Lehan,
Aye.
Ms. Swam,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Yes.
Ms. Nair.
Aye.
Okay, so that resolves complaint number 19-0446 and Ms. Lee's license renewal. Now to discuss the matter of the continuing education. What my understanding of where we're at right now is there are two renewal periods that Ms. Lee has not completed the continuing education. We did receive notification from Ms. Lee within the last several days that she has completed CE, but it does not appear that that was done within the required renewal time. Staff, any additional information that I'm missing?
The information that we received from Ms. Lee about her, I believe it was 33 hours completed between December 7th and 8th, was received this morning.
December 7th and 8th, as in like the last 2 days?
Correct.
Okay. And the deadline to complete the CE was before the end of the renewal period?
Correct.
Okay. Board members, additional questions for staff or Ms. Lee related to the continuing education?
What was the renewal period ending date? October?
October 31st, yes.
And there are again two renewal periods, this current renewal period and the prior renewal period.
That's 60 days.
Yeah, and Madam Chair, if I may also, R423-204C does require licensees to hold on to their renewals, not renewals, I'm sorry, but CE, showing proof that they've done it for 5 years.
Can I ask a question because I'm not familiar with your tracking system?
Yes, Ms. Galvin.
It says that the CE was completed between 12/7 and 12/8. She represents that she took the courses previously, but took the exams and entered them on 12/7 and 12/8. Is that possible?
Yes.
Yeah.
It is.
But it doesn't, you don't get credit until you enter it.
Okay.
And typically the date that you complete the test is the date that the CE certificate is issued for. It takes the NABP a couple days to actually process the CE and get it into the CPE monitor.
And that's the day you would get your certificate as well.
So you could, I suppose, complete it on paper, but it's not actually completed because it requires the assessment until you enter the exam.
Can I say something, ma'am?
Yes, Ms. Lee.
So I had explained to Ms. Jennifer Mitchell the reason why I was not able to complete those 30 CEs prior to the October 31st, 2020 deadline. That was because I was in and out of hospitals, and I was really ill and almost died in the hospital, but luckily I did not, and that happened in 2019. And I know that I'm not trying to make excuses for myself. I could have done it in 2018 or in 2019 or in 2020, but I was severely ill and I'm actually still recovering from my sickness. I had to do rehabilitation and everything. And basically I was disabled for a long time. And the reason why, and that was the biggest reason why I was not able to complete those 30 CEs prior to the deadline of October 31st, 2020. And I made a really big effort to try to get them all done. I mean, I did I printed out all the exams and I did all the questions and everything, but I just way before the last 2 days of the
Ms. Lee, we're talking about 4 years total of CE here.
No, I'm only talking about the previous period. I'm only talking about October 31st of 2020. That's all that I'm talking about. For
But
the
you are missing them for 4 years, correct?
No, I'm not. I did. I don't understand why you're saying that the last time that you got anything from me was on September. Last was on September 2016, when I have done them all up until the October 31st, 2020 renewal period was when I was not able to complete them.
Do you have proof of that, CE?
Okay, so another problem that right now I don't have proof of it because I had a water. My house was flooded. The house was flooded, and I have a record of all that and everything, and it flooded, and I had to throw so many of my personal items away. So a lot of those certificates that I had in my folder was damaged by water, and they had to be thrown away.
So they should be on the CPE monitor though. Electronically, you should be able to pull that up.
I did that was not reported directly to the CPE, but that the only thing that I had was a record of them in paper.
But to Mr. Gandhi's part,
a lot of times you have to send all the stuff into the CPE to have them recorded, but then I didn't have time at that time, or I didn't think that I needed to do that, so I kept the paper certificate with me. And I went to CE seminars and all that kind of stuff, and I did all the hours and everything, but I just had to send those in to the NABP in order to have it recorded, and I didn't send them in, so that's why I didn't. They were not recorded in the system that you guys could see.
Mr. Solar, do you have a question?
Ma'am, I have a problem with her explanation as follows. I've renewed my license 30 something years now. Every time I come to the question where it says, have you done your CE? I stop and I say, did I do my CE? And if I did and I can prove it, I answer yes. But if the answer is no, I know I haven't done my CE because of illness or whatever, my first impulse would be to contact the board office and say, hey, I haven't done my CE. What do I need to do to fix this? Instead of answering yes and moving on. And so my problem is, A, we can't prove that she's done any of the CE, but then when she gets to the question, why is she answering yes when she knows the answer should be no? And so I find her story suspicious.
No, I did do it, sir. I just don't have a record of it because my house was flooded.
But why did you answer yes on the question? You should have, at that point, when you get to the question on your renewal application, you should say, oh, I haven't done it. I can't prove it. I better contact the board office and find the remedy. I don't just answer yes and move on.
Because the problem is that I did complete the last, for the period of September 2016 until 2020. I did complete that, but I don't know because my house was destroyed for a year. I didn't have a house to come back to a year. So, I mean, I lost a lot of stuff in my house, including those documents. So that's
as a pharmacist, if something isn't documented, then it didn't happen. We don't have any documentation, so we have no way to prove that it happened.
I'm not saying that I don't have that. I'm just saying that is just what I'm thinking of right now. I can go back and try to find from September 2016 up until the previous renewal period, but likely if I cannot find anything, it's because of the flood.
Okay.
Can I?
This is Goodman. Oh, go ahead.
Go ahead, Nick.
I was going to say, I understand that we're taking these two issues separately, but based on where we are now, I think the credibility and ability to see this individual as somebody that we can license is in question. I'm rather concerned.
I don't see why you feel like that because
Miss Lee,
ma'am, this is for discussion.
Miss Lee, we're discussing. Please quit talking at this point.
Lori, I have a question. She has the records of the flood at her house, but she doesn't have the records of her CE. Is that correct? Is that what she said?
I lost the flood.
You what?
I lost the documents in the flood, sir. It flooded my whole house.
And you said, I have the documents showing the flood, right?
Because when you have a house flood, you have to report it to the insurance company. That's why I have a record. But it flooded my whole house. I didn't have a house to come back to for over a year. And I lost like 90% of all the items I had in my house.
I unfortunately think every conversation here starts with an excuse, another excuse, another excuse. That's why I voted no on the other issue.
It's just a fact, sir. You don't like the facts, but that is a fact.
Miss Lee.
You have no facts. You have conversation, which is all hearsay. If I believe everything that you say, you should be able to back it up. You can't back up anything with any documents that prove what you're saying. It's only just hearsay, and that doesn't
allow me to complete CEs without having to submit it to the monitor, to the system. I have paper documents of it. I went to send so many.
Now you have paper documents. I thought they were all destroyed. In the
Yeah.
flood. Well, which is it? Just pick a lane and let's
In the
go.
flood. It was going in the flood. I did admit.
Well, you have the documents, but they're gone in the flood. But now you have the documents. What is it?
When I said that I did not complete the CEs for 2020 renewal period, I admitted it. I did not do that because I was in the hospital. That is a fact.
What does our grid
I did.
I'm done with this.
Okay.
If I don't, then I have
One
to.
at a time. Miss Lee, please do not speak unless we ask you a question or acknowledge you.
Maybe Ms. Lee needs to be reminded that it is providing false or misleading information or omitting material information in any communication to the board employees or agents is unprofessional conduct.
So what does our grid say that we do in this situation? There are 60 missing CEs that don't have documentation or proof.
I can read the text to you. It says $100 fine per each deficient hour of CE. So that would be $100 times 60. So yeah, $6,000 in terms of fees. 1.5 times additional CE required for the next renewal period. So 60 times 1.5 would be 90 hours. Automatic audit at next renewal. Repeat offense will result in board appearance. Those are the 4 criteria from the grid.
Thank you. Is that what we'd like to go with? Or do we want to maybe?
That's a motion. I'll second it.
Well, I don't want to make that motion, but I also want to acknowledge Mr. Goodman's point that I like Mr. Goodman and Mr. Minkus, I am having difficulty with this individual's credibility. And I'm just uncomfortable because of everything that's been said so far. I'm just uncomfortable with her practicing.
Mm-hmm. Ms. Lee, are you currently practicing in a pharmacy? Are you working somewhere?
No.
I didn't hear you.
Oh, can you hear me?
Yeah,
No,
I
I'm
can.
not currently practicing.
You're not? Okay.
I'm just prior period. You guys were making it so lenient.
Miss Lee, the board is discussing the matter at this point in time. Please refrain from making comments unless we ask ask questions of you, please. I mean, I see both everyone's point on this. We have a typical standard for how we handle these matters related to the continuing education. I think the difference is that we are talking about multiple renewal periods as well. There is a number of situations where she's been misrepresenting information, it seems like, to the board staff, and shows some tendencies to potentially be able to be challenged to be regulated, to Mr. Goodman's point. I don't know, Mr. Solari, is that your motion to go with the standard?
If we were to go with it?
I'm not sure what choices we have. She's already passed the psychological evaluation for fitness for duty. She's been declared fit for duty. So I don't, unless somebody else has any idea, I do have issues with her credibility, but I don't know what to do about that. So in the absence of knowing what to do, the best we can do is go with the grid unless somebody else has a better idea.
Well, I don't have a better idea, but I have a question about maybe if we go with what the grid states and then make a contingency if she doesn't sign, that we go to hearing or deny the application. I don't know. I don't know what kind of contingency we could make, but.
Well, we already have as a contingency on the other, if she doesn't sign and doesn't pay the consent agreement, that we would deny the application. I would make a proposal that if we did the standard discipline for failure to complete the CE in this particular case, that we would make a motion to go to hearing.
And I can support that. I think that's reasonable. I don't see any other option unless legal counsel or board staff have any suggestions for us. That's the path I'm headed down.
And at which point, if she could show us proof that she completed the CE in a different time, that evidence could be heard.
Yeah. All right. You want to put it in a full, complete motion, Mr. Solari?
Let me take a stab at it, and legal counsel, please help if possible. Okay, so per compliance grid, per grid, she needs to do $100 fine for each deficient hour of CE. If she cannot prove that she's done the 60 hours for the 2 renewal periods, she will need to pay $100 for each fine she can't prove. Secondly, 1.5 times additional CE required for the next renewal period. So again, whatever she can't prove she has completed, she will need to do 1.5 times the required hours there. Number 3, automatic audit at the next renewal for 2022. Repeat offense will result in a board appearance. So we'll go straight with the guidelines from the grid. Failure to comply within 90 days, and we would go to hearing. If she fails to comply, we will not renew her. Renew her license. Anything else I'm missing?
Are we going to give a timeline on how long she has to prove it? Just curious if that's something you want to do.
Would it be
Say again,
possible
sir?
to give her the 30 days to sign the consent agreement along with, at that time, she'd be able to prove
or
during that time too?
Sure. So give her 30 days to sign this consent agreement for the continuing education. If by that time she can prove whatever CE she's completed, we'll take that into consideration and give her due credit for it. If she can't, then from the time she signs the consent agreement, she has 90 days to complete the requirements as outlined by the grid, and failure to do so will proceed to hearing, and we will not renew her license until she has satisfied all our requirements.
So do we have a second?
Second.
Second.
All right, motion by Mr. Solari, second by Ms. Snare. Any further discussion?
I have some questions. So if she doesn't comply within 90 days, you said go to hearing, or is that deny?
We would deny her renewal request for her license, and then we would have to would we need to take additional action, or would that be the end of it?
Well, with the denial, she could appeal that and request a hearing.
Then that would be her prerogative, I guess. I don't know. Help me with that. What is it better?
And yeah, that's probably the best bet if you're making the renewal contingent upon assigning or compliance. The one concern I may have is if the board approves this, we may want to look at consolidating the 2 cases, because otherwise they're both have provisions that if she complies with one of the offered consent agreements, then under the provisions of that, she would be renewed, but it would still be, you'd have another one that if she doesn't, it would be denied. So they'd be somewhat conflicting. It would be better, in my opinion, to consolidate them, have all the requirements under one order. Jean, what are your thoughts on that?
I agree. I agree with you. And we could put it all in one order and the cases would be consolidated.
Then I'm okay with that. I didn't make the previous motion, I don't believe, but do we need to go back to that?
No.
Okay. Then I would amend my motion to also include what you suggested, consolidating, so that we visit this only once in the consent agreement.
Second.
Second.
Any further discussion?
We do need a roll call.
Yes, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Ms. Lehan,
Aye.
Ms. Lee,
I'm sorry.
Ms. Walmsley.
Oh, you cut out. Aye.
Sorry about that. Mr. Tong,
Aye.
Mr. Goodman,
No.
Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you. Ms. Lee, the staff will be in communication with you. Appreciate your time and attendance today.
How long will I get the letter in the mail regarding this?
Probably a couple of weeks.
A couple of weeks. Is it gonna be certified mail or just regular mail?
It'll be by email and Jennifer, I believe regular mail.
That's correct.
So, okay, so since you already made your decision, then there's nothing more I can say, but I just want to understand. So what is it? Can you explain to me the motion again? I understand about the fee and all that kind of stuff, but then what is it about the night regarding my CEs?
Ms.
So-
Lee, the staff
Ms.
will
Lee,
be
I
in
will,
touch.
Madam Chair, if I
Staff will
may.
reach out to you. Go ahead,
Yes,
Dr.
we'll,
Gandhi.
we'll reach out to you, Ms. Lee, and explain the details.
By email, sir?
Yes, that's fine.
Okay, all right, thank you, sir.
Thank you for your time.
Okay, let's take a 10-minute break and we'll reconvene at 25A.
And we need more than 10 minutes.
I agree.
Okay, welcome back, everyone. We will pick up. Let's return back to Dr. Gandhi. If you would direct me, we'll go back to, was it 17C, Galil Medical?
Yes, Mr. President, I believe Galil is back online to talk about our discussion from this morning.
Okay. Representatives for Galil, if you would state your name for the record, and welcome back.
Hello, Joe. It's Falcon Patel from actually Boston Scientific, representing Galil as well.
Okay, thank you.
Eric Walder here as well. Same thing from Boston Scientific, but representing Galil as well.
Okay, thank you.
Mr. Leba, can you give us the item number?
I sure can. It is 17C and tab 17, non-resident manufacturer permit applications requiring board review.
Got it. Thank you.
Okay, board members, we are back. The permit holder was going to go back and look at shipping and the discrepancy of the permit number and come back to us. And with that, Mr. Patel, I will hand it over to you.
Yes, sorry. So we did go back and we looked at the issue. So our investigation showed that prior to our acquisition, Galil did not have a license for Arizona. Okay. And so when they identified that they needed a license, that's when they submitted that in March for that application. And then when we acquired them, Boston Scientific, we already had a license. So that's when we filed for a withdrawal for that application. I guess that was in motion. So we were, if you ask me, yes, Galil was shipping in Arizona without a license prior to its acquisition to Boston Scientific.
Mr. Patel cut out on my end. I don't know if everybody else heard that or not.
I heard bits and pieces.
Could you restate that, Mr. Patel?
Yep. So prior to Boston Scientific's acquisition of Galil, Galil did not have a license to ship into Arizona, and they were shipping in Arizona without a permit.
Okay, thank you for that. Board members, do you have questions?
How long were they shipping into Arizona without a license?
George, I have George on the call from Galil, so maybe he can answer that question.
Hello again, George Pogorzelski, Quality Director for Galil. So I joined with the company in 2016. The entity was established here in the U.S. in 2011. So I would assume that the whole time they've been doing business here in the U.S. They've been shipping without a license.
Okay. Board staff, any comments before I ask for a legal opinion on this?
I do, Mr. President, if I may. Do you have an inventory of what was shipped during that time period?
Not readily available at this moment, no.
How do you think this happened?
From what I gather, certain members of the Galil management were under the impression that the medical devices were subject to these regulations because of the kind of the comment that it was a pharmaceutical.
So the devices we ship, Joe, are all approved by the FDA, and they all go to a clinic or a hospital, right? And they're administered under a doctor or a pharmacist, I guess, right? Most likely they're under a doctor's supervision because they're medical devices. So the requirement for need to have a device distribution license was known by Galil.
Okay, Dr. Gandhi, did you have something else?
No, Mr. President, right now.
Yep. I will add to that as well. Since transferring over to Boston Scientific, we do have robust procedures in place as a part of Boston Scientific to identify when those licenses are needed and to implement those as required.
Board members, what questions do you have?
So I guess this is a question for legal counsel. Since Galil does not hold a current license, and they were engaged in activity that is regulated by us, what options do we have in terms of action? They're asking to withdraw their application because they no longer need it because Boston Scientific has one, but that doesn't address the act of the shipping without a license, in my opinion. What options do we have?
Lori, one option would be to deny this application. Another option would be to fine them for what they shipped in over the period of that time.
And I would agree with Mr. Labe. I was trying to ask if you wanted to go into executive session, but I was muted. But you could deny the application. You could assess them a civil penalty for engaging in the shipping without a valid permit. Issue them a cease and desist. And probably all of the above.
Have they been shipping with the Boston Scientific application? Is that why they're asking to withdraw? All right. So Boston Scientific is appropriately shipping, but has the application. But you brought it along when you bought Galileo, you find out that they didn't have an application.
Right. So the application was
for what Galileo did, a company that you had purchased.
Yeah, correct. The application was started in March, and the distribution was taken over by Boston Scientific in April.
Okay. But we go back to 2011.
But
Mr. Pogorzelski, did you know you didn't have a permit coming into the meeting today?
No, unfortunately, I was given the permit number we cited earlier as what was the permit. I was misinformed in terms of the status of that. I thought that was the active one that we had previously.
Mr. Walder, did you know?
No, same thing for me as well. Was under the impression that that was the active permit for Galil Medical up until now.
Yeah, we had been using a company Pharma license as a assistance in terms of managing the Galil licenses prior to the acquisition.
It's just interesting to me that the conversations were going on, and the reason why I asked those questions is this. The conversation and exchange was going on with board staff, and there was communication taking place. Then when asked for the previous 2 years shipping that came into Arizona, it went radio silent. So to me at that point, you wasn't a permit and the communication stopped. And that doesn't sit very well with me on that. Board members, if you would like
and then
legal
after that, I think, Dr. Leba, there was a request to withdraw shortly after that. They quit responding and then they responded again and asked to witdraw the application. I think so in the time frame.
I feel like there's a little more to the story here. It would be my opinion, board members, if you want legal advice, I don't think that that is a bad option at all. But looking at this, my civil fine, as we have done in the past, and deny the application. But I want you to feel confident that if you want legal advice, that we should go do that. Let me ask legal advice a question. Do you suggest that we go into legal executive session for legal advice?
If you have additional questions, I believe you've been provided with your options, but if you want to discuss those options in further detail, then I would recommend executive session.
Okay, board members?
Can I get just a quick history one more time? So for some reason, I can't keep it straight in my mind. Boston Scientific bought Galil.
They bought,
And out of the three of you, which three of you worked for Galil?
just George.
So I worked for Galil Medical. I was hired by Galil in December of 2016. I was hired actually by the company Biocompatibles, right? So you have Biocompatibles, which is BTG PLC.
Mhm.
Purchased Galil. Boston Scientific purchased BTG PLC in August of 2019.
Okay, and Biocompatibles has
A license.
had a case brought against them as well. That was public through
Biocompatibles was diversifying into the medical device space in the late 2010s, right? So Biocompatibles originated as a pharmaceutical company. So they were more directly involved in pharmaceutical products. They started buying device companies, and that's how they then acquired Galil Medical.
And
Okay, so what's the, yeah.
I was just going to add to that on page 2329 of the board book. It starts the discussion about this. Dr. Gandhi reached out several times to try to get an answer regarding this matter. And I also had reached out regarding this matter about their relationship with Biocompatibles.
And they had a case against them through the DOJ.
Correct.
For which they pled guilty.
Galil Medical was always distributing product itself. We were never distributing product through Biocompatibles until just this April 2020 when that transitioned to Boston Scientific.
At this point, I just think we don't want to give them a license and they don't want a license. So we both parties agree on that. The question is what Mr. Leba brought up. Is there some kind of a civil penalty we can settle on? And then either we deny the license or allow them to withdraw it. Either way, we both reach the same conclusion as far as that's concerned. So I'm not sure what difference anything else makes at this point.
I would say a denial of the application. There will be a lot of reporting that this company will need to do on behalf of one denial. And I think that we can't just close our eye to the fact that since 2011, shipping did take place.
And I don't disagree with that. I'm not sure. I just don't want to go down the path of getting into their corporate structures and who bought who and all that. At this point, as long as we close this out one way or the other, that's what both parties want.
I agree with your recommendation, Mr. Leba, to deny the application and assess a civil penalty.
But how about addressing the shipping here for 9 years?
That's what I'm talking about with the civil penalty.
Right.
Yeah.
Now, granted, we don't know how much it was, so I don't.
Would that change your opinion on how much to do for the civil penalty?
No, but I think our maximum is $1,500, isn't it?
$1,000 per violation.
$1,000 per violation.
Is our max.
But that could be based on volume, number of years. It could be a number of factors.
Typically, when we've assigned the civil penalty, we have granted or we've continued with a permit. I am almost leaning towards denial of the application and moving on. And I'm just throwing that idea out there. We've not had before where we've continued to let somebody operate, where we've denied an application. This is a little bit unique in that regard, going back 11 years. I don't know, that's going to be a tough one. the denial of the application is reportable to every board that they're licensed with.
I want to ask for legal advice.
There you go. Okay, I have a motion for legal advice. I will second that. All those in favor?
Aye.
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 Okay, gentlemen, we will go into executive session and then we will return into this room.
If anybody on the staff's there, I haven't gotten an invite to executive session. This is Goodman.
Hold on, Mr. Goodman. I'll get you over there.
Thank you.
Okay, thank you for your patience. Executive session, board members, I'll open up to you for any follow-up questions or entertain a motion.
I'll make a motion to deny the application and assess this $1,000 civil penalty.
Ms. Nara, it would be my, can you guys hear me?
Yeah.
It would be my recommendation to, besides just putting 1,000 on it, to look at the number of times that it has taken place. So meaning that we deny the application, allow Galil to work with the executive director and AG's office here to come up with a number of occurrences that transpired with the records that are available, and from there negotiate a consent and bring it to the board for an approval at the next meeting. And I think there could be a negotiation that takes place there.
I would be fine with that. I would like, I mean, I'd prefer to have it settled today, maybe like $1,000 per year or something. I think that's preferential, but if we think that it'd be better to have it be negotiated, I would authorize staff to do that.
And the only reason I say that is we have no idea the number of times.
And for the record, the denial is based on the 9-year history of shipping into Arizona without a permit.
Yes, that's correct.
So Ms. Neri, if you made a motion, I'll ask you to just kind of rephrase that and then I'll ask for a second.
I would amend my motion, excuse me. I would amend my motion to be to deny the application based upon shipping into the state without a license and to work with board staff to assess the civil penalty, pending on information on how many units were shipped into Arizona.
It wouldn't be issue a civil penalty. It would be to negotiate the terms of the consent agreement for a civil penalty.
Thank you.
Second.
Okay, I have a motion and I have a second. Is there other discussion?
And
Any
we will,
clarification needed by council?
just a roll call. And the second was Dr. Tong?
Yes.
Yes.
Roll call. Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tom,
Aye.
Mr. Goodman,
Yes.
and Ms. Nair.
Aye.
Okay, we'll reach out to Gilead Medical.
Okay, thank you for your time today. 17D. Is that where we're headed?
We would like a decision made on that. I know that Elizabeth and April have reached out to Louis Pharma. I don't see them on the call. Either we can still hope that they'll show up today or tomorrow, or we can table it for the next meeting. Or you can take action.
Board members, what are your thoughts on that?
I think we can wait till later or wait through tomorrow and see if we can get them. That would be nice.
Dr. Gunny, move on from there. We'll keep it open. We don't need a motion or a vote or anything. We'll come back to it if we can. Thank you, Mr. Minkus. Okay, next agenda item.
Mr. President, if I may, same thing for number 15, Women's Choice Pharmaceuticals. Just leave that open until tomorrow.
Do we have a representative by chance?
No, they haven't reached out, but I don't see them unless they snuck in.
Let's do the same.
All right, so noted.
And then that brings us to tab 25, conferences.
Yes, we have conference A, B, and C scheduled for today.
Okay. Conferences 25A 20-0009. This is for Sean E. Samet.
Mr. Samet is online. I'm requesting. He is unmuted.
Okay. Mr. Samet, if you'd please state your name for the record, and then if I could get the compliance officer as well to give us an overview before, and we'll go from there. So, Mr. Samet?
Sean Samet.
Okay, thank you. And did we have a compliance officer on this?
That was staff. It's Jennifer Mitchell.
Okay, Ms. Mitchell, would you mind walking us through this overview? And then after that, Mr. Samet, I'll ask for your opening remarks as well.
Okay, so in January of this year, Mr. Samet left a voicemail about reporting charges. I followed up with him with an email letting him know he needed to disclose, and we had multiple email exchanges back and forth for quite some time. In January, we sent a subpoena to Mr. Samet requesting court documents and an explanation. We did receive court documents, but we did not receive an explanation. So in researching the matter, I found some news stories related to his charges, and I was a bit concerned about Mr. Samet's well-being. And he contacted me today to let me know he has not renewed his license, so it's currently suspended.
Thank you. Mr. Samet, would you like to make a comment?
So I just would like to share with the board that I take full responsibility for my inaction in complying with the subpoena immediately and forthwith, and I do sincerely apologize for that. The past year has been a bit of a challenge medically for me. I've been in and out of hospital with a necrotizing fasciitis infection.
Just a minute, if we need to go into executive session for confidential health information, we can do that. Mr. Samet, you're not obligated to disclose on the public record any health conditions.
I'm comfortable at this point, but should that become uncomfortable in the future, I can avail myself of that option, correct?
You may, but once it's out there, it's out there.
Okay, sure, we can go into executive session.
Okay, I'll make a motion to go into executive session to hear confidential health information of Mr. Samet.
Second.
I have a motion, a second. All those in favor?
Aye.
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 Any opposed? Okay, Mr. Samet, you'll be directed on your screen to enter a private meeting room. Okay, we are back from executive session. Thank you, board members. Thank you, Mr. Samet. Board members, I'll open it up to any discussion or questions.
I have a question. Mr. Samet, if given the opportunity, would you want to surrender your license in Arizona?
I'm sorry, can you say that one more time?
If given the opportunity, would you want to surrender your license in Arizona?
Voluntarily, yes.
Mr. Samet, do you understand that a voluntary surrender is treated as a revocation?
So, I mean, still reporting it to other boards, however, it would be up to those other boards to determine my fitness to continue, correct?
It would be reported to the National Practitioners Data Bank, and other boards and other state agencies would have access to that information.
Okay.
Mr. Samet, are you agreeable to that?
Yes.
Okay.
Ms. Snare?
I make a motion to allow him to surrender his license.
I have a motion. Do I have a second?
Mr. President, if I may, that would be a consent agreement for voluntary surrender.
Yes.
Okay.
Goodman seconds with that amendment.
Okay, thank you. And I have a second by Goodman. Legal counsel clarification or additional discussion before final roll call?
Now that's on the basis of his failure to comply with the subpoena.
Right.
Yes.
Can I ask a question?
Yes.
Other than a voluntary surrender, are there other routes to deal with this issue?
Well, the board could make a decision to go another route, and if discipline is imposed, you have the ability to accept that or deny it. If you deny it, we could move to a hearing. It would be a cleaner way to open to than going down a different route. A hearing is a more formal process.
Perhaps if Mr. Samet doesn't have any intention of practicing in Arizona, he would agree to let his license expire and pay a civil penalty for not complying with the subpoena.
And right now his license is expired, so it's been changed to the suspended status.
What would be the civil penalty for not complying? That would be something we would decide.
Yes.
It could be up to 1,000, but again, now you're looking at discipline at the same time. So either way, voluntary surrender or a civil penalty is discipline.
And that's true, but a civil penalty is less serious than a...
Correct.
Ms. Snare, were you heading in a direction, or do we need to do more discussion? Did we have a motion? We had a second.
Yeah, for discussion, just to act in the best interest of Mr. Samet, I tend to agree with Ms. Galvin. Voluntarily surrendering your license is a pretty severe penalty with a lot of future consequences. He might be better off allowing his license to expire and pay the civil penalty just so he can keep practicing elsewhere if other boards see it fit to allow him.
What would prevent him from reapplying tomorrow? We just get him back in front of us.
Either way, whether we allow him to voluntarily suspend his license or revoke his license, or whether we allow it to expire, either way, he's going to have to file another application, and the board staff would do their due diligence. So we would revisit this if he reapplied.
Mr. Samet, what is your opinion?
I mean, ideally, I would perhaps prefer to go the route of the civil penalty. Again, I'm trying to make it very clear. I am accepting responsibility and in what I did and failing to comply. So I want to do my best to make that right. But I also recognize that I'm 27 years old, and you know, healthcare is something that is important to me, and I would like to hopefully keep that that future ability to do that once I'm in a better place to do that. So if it is possible to go forward with that, I would appreciate the board's ability to allow that to happen.
Okay.
I would amend that to be.
Maybe withdraw your motion. We can withdraw the second and we'll start over.
Okay. Withdraw my motion.
Withdraw the second.
Okay, thank you.
I'd be willing to do to let him allow. Oh, his license is already expired. To do a civil penalty of $250 for failure to comply with the board order.
And that would be payable in what period of time?
90 days.
Or go to hearing.
Or go to hearing.
Okay, I have a motion. Do I have a second?
I'm willing to second that, sir. I think that's reasonable. And
Thank you.
It is in his best interest.
I have a second by Mr. Solari. All those in favor, we'll do a
That's
roll
a roll
call.
call. Roll call. Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Okay, motion carries.
Okay, thank you for your time today, Mr. Samet.
Thank you to the board, and please just know I do appreciate it, and stay safe.
Thank you.
Thank you.
Thank you.
Thank you.
Mr. Labor, you're muted.
Thank you.
You're muted again.
Hit it. Is it working?
Yeah.
Okay. 25B 20-0280 Ishmael Abun Hainea. Complaint 20-0280.
Mr. Labor, I'm recused from this matter.
Thank you. Making note of that. Do I have representative for Ishmael?
Mark Bozen, counsel for Ishmael Abahani.
Okay, thank you. Welcome to the meeting. Are you representing today on behalf of Ishmael?
I am. If it pleases the board, shortly after the notice was received to appear on September 14th, I sent an email back to board staff notifying board staff that Mr. Abahani is currently in custody of the Federal Bureau of Prisons. He's finishing a behind-the-walls sentence. He's scheduled to be released on December 19th. He will be under ankle bracelet home confinement for 2 months following. It would be my request, because I think the board would benefit from hearing from him, that you table this matter until the next meeting, as he will be unable to practice pharmacy between now and then anyway.
Okay. Thank you for that,
If not, I'm able to proceed without his presence. I have permission to do that.
Before we move to that, Mr. Heiber, would you please give a overview of the case, and then I'll turn it over to the board for a decision.
Sure. Complaint number 20-0280 involving Ismail Abu Hanaya. It's the category of this complaint is unprofessional conduct due to felony convictions and failure to notify the board of those events. We originally found out about this based upon some news articles concerning a federal investigation of a Dayton, Ohio located pharmacy operation. The complaint was opened in June 23. against pharmacist Abu Hanaya. Additional information was obtained in respect to the federal grand jury indictment and subsequent U.S. District Court judgment in a criminal case involving the United States of America versus Mr. Abu Hanaya. He failed to notify us, but he did respond to a phone call I placed to him. And then we subsequently, he hired counsel, he retained counsel, and then he provided us with some responses, and those are included with the rest of the materials in the complaint attachments.
Okay, thank you. Board members, do you have questions on that? The question I would pose to the board would be, waiting to hear from him, would it change anything that is in front of us at this point?
Mr. President, if I can just, for me personally, it's always helpful to have whoever's in trouble in front of us to tell us the story or answer the questions. So I personally would prefer if we tabled it and just waited till he would come before us before we made the decision. But that's my personal opinion.
Okay. All right. Having said that, I think I'll take that recommendation and table this until the next meeting. Would the next meeting, Mr. Bozen, will he be available to represent himself?
Yes, he will be on home confinement, so he should be able to log into the Zoom meeting and be able to present. If something changes, I will certainly let the board know, but he is scheduled to return home on December 19th. He will be confined to his home for 60 days following that. So the next board meeting is February 3rd and 4th. He should be able to join us from his home residence to present his case.
Okay, thank you, Mr. Bozen. Having said that, we will table this and move on to the next case. 25, thank you. 25.
We need to vote on that.
And not if we're going to table it. We're not taking any action.
Okay.
25C 18-0479. I am recused in this case, and we'll hand it over for Ms. Walmsley.
Thank you, Mr. Leba. I see we have Ms. Kissel and Mr. Hupp with us. Can you please state your name and affiliation, please, for the record?
Sure. This is Jonathan Hupp, counsel for Ms. Kissel.
Beth Kissel.
Thank you. Dr. Gandhi, can we have the compliance officer, a member of the staff, do a brief summary of why we're here today? And then we'll take a statement from Mr. Hupp or Ms. Kissel.
Steve Hyber, compliance officer. Complaint number 18-0479, unprofessional conduct, which involves a post-receipt alteration of a DEA Form 222. The summary is as follows. The board received an email notification back in December of 2018 from the pharmacy director concerning the termination of a pharmacist in charge at Save on Drug, number 3931 in Yuma, for alteration of a DEA Form 222. The notification did not provide detail, so a follow-up request for additional information was sent to management on January 13. On January 28, a report of the investigation conducted by Albertsons Asset Protection was received and is summarized below. On October 3rd, 2018, AP, that's Asset Protection, received a call from pharmacy DM Aaron Epley about concerns with PIC Kissel and to request assistance. On October 18, 2018, Epley received an email from pharmacy technician Nancy Castro concerning PIC Kissel, reporting to work late on the 17th of October and being observed in an incoherent state. In addition, 2 tablets of tramadol had been found on the floor of the pharmacy and the pharmacy restroom. 3 days later, on the 21st of October, pharmacist Kissel failed to show up for work and was placed on leave. 5 days after that, on the 26th, management conducted a controlled substance audit, and the results of the audit indicated some discrepancies for amphetamine, salts, oxycodone, tramadol, and diazepam. 2 DEA Form 106s were submitted by the permit holder to report the audited losses. Note that box 10 on each form indicated that it was a type of theft or loss as unknown. On the 20th, Asset Protection conducted an interview at store 3931 with Kissel. PIC Kissel was asked about the altered 222s, and there's copies of those attached in the investigation report, and receipt overrides of the product entered into the pharmacy inventory system. Kissel acknowledged making the changes, but provided no explanation as to why or what happened to the missing oxycodone. Kissel declined to provide a written statement and left the store without further comment. After the meeting, Kissel was placed on suspension and terminated in December 12/6. And just so you know, the reason for that delay is Kissel was on a leave of absence during that time. So they waited for that leave of absence to end before they did the termination. On March 6th of 2019, an initial summary was submitted by myself to the board management to support issuance of an interim order requesting Kissel to submit to a drug screen and substance abuse evaluation. Kissel responded through counsel and completed that order on April 17th. I visited the store on April the 18th, the next day, and conducted a controlled substance audit on the drugs reported by the permit holder on the Form 106. On May 13th of 19, Epley provided a revised AP, Erin Epley, she's the pharmacy DM, provided a revised AP investigation report to correct some typos that I had noted on the original AP report involving the oxycodone 20 milligram. It was erroneously represented on their first draft report as oxycodone 10. Then on June 7th, Albertson submitted a revised 106 to account for an error they had made on that because of their faulty report. Then in September, documents were provided to board staff by Mr. Hupp, counsel for Pharmacist Kissel, with containing medical records, screen prints of instant message communications between Kissel and pharmacy DM Erin Epley and the store manager Ramona Williams. Those are included in this report today. In conclusion, on September 26 of 2018, Kissel was observed on video making a negative 100 adjustment to the oxycodone 20, using her own user ID on both the days on hand report as well as on the C2 inventory log. And there are images, screenshots of those dates and times that match up with the date and time stamps on the reports included in your materials. Kissel did not notify Albertson's management of the negative adjustment. The pharmacy subsequently reported 103 oxycodone 20 loss to the DEA. On the 17th of October, Kissel, once again, is observed on video, updating those two systems, this time inputting 200 amphetamine 20 and 1400 oxycodone 5 as the quantities received. Invoice records provided by McKesson indicate number 300 amphetamine 20 milligrams were shipped to the store and 1500 oxycodone 5 were ordered and delivered to Save On 3931. A copy of the DEA 222 form and shipping invoice provided by McKesson indicates 300 amphetamine 20 and 1500 oxycodone 5 were shipped on October 17th. On the corresponding DEA form initialed by Kissel on file at the pharmacy, it indicates 200 amphetamine 20 and 1400 oxy 5 as the quantities received. In addition to those changes, there were actual alterations on the Form 222 and McKesson invoices on file at the pharmacy. Both the 222 and the McKesson invoice have visible override changes made to the number of packages on both the ordered quantity as well as their receipt quantity. And those images are included in your packet. The alterations observed on the store records are not visible on the wholesaler record copies that we received from McKesson. Kissel modified the invoice and Form 222 records rather than alerting management concerning the quantity discrepancies. The pharmacy subsequently reported losses of 99 amphetamine 20 and 112 oxycodone 5, in addition to several other missing drugs.
Mr. Hyber, does that conclude your report?
It does.
Okay. Mr. Hupp, Ms. Kissel, do you wish to make a statement?
Yes, if I could make a statement. Mr. Hyber referenced some information that I provided to the board actually back in June, then again provided it to Mr. Hyber and Ms. Dodge in September regarding medical conditions and medical records. But also there was additional information provided to the board, namely a November 15, 2019 letter, which I hope is in your packet. It is not in the investigative file that was disclosed to me, but the reason I'm referencing that is because it was provided to the Yuma County Attorney's Office and forms a basis for the reason that this case was ultimately dismissed as a criminal matter, because it focuses on the Form 222 that's at issue from October 15th to October 17th. And what is made clear in that letter is that the Form 222, which is allegedly altered, it's filled out by Jocelyn Morris on October 15th. It is then left in the pharmacy in a stand-up file that's accessible to anyone in the pharmacy. It's not locked, it's not kept behind any kind of secured measure, until 10/17 when Ms. Kessel is tasked at the end of her shift to count it. If you look at the Form 222, which you have copies of, the handwriting on the right where Ms. Kissel is noting what was counted does not match what was allegedly altered on the left. In addition, it doesn't match the notations that were made on the invoice. So yes, the indication there, and Ms. Kissel will tell you she is not the one that made the alteration on the left side of the Form 222. All she did on the 17th was count what was there and then make the correct notifications in the computer system related to that. So I also want to posit to the board of, if she is the individual who diverted these drugs, why would she log into the computer system with her own biometrics and also her own signature and notate that? And also I think it's important to note that, as Mr. Hyber did state, she was ordered to comply with a substance abuse evaluation that was found no substance abuse or substance use issues, and she passed all drug screens. And that was a hair follicle test that does relate back to the time period in question. As to the lack of reporting it or acknowledgement or that it wasn't reported appropriately, we do appreciate that the board tabled this at the last conference to make sure that the documentation related to her medical issues and her being placed on leave was included in the packet so that you could review that. But just a brief summary is that on the 17th, after she made these changes in the system, because that's what she counted, she was not scheduled again to work for 2 to 3 days. And then when she was scheduled to work again, she had been placed on administrative leave for these medical issues. So it wasn't a issue of she was supposed to be at work the next day and didn't report anything. It was, she didn't even get a chance to come back in and report anything because she wasn't scheduled to work and was already placed on medical or administrative leave. So I think Ms. Kissel had a statement she wanted to make, and then we can address any questions. Thank you very much.
Thank you, Mr. Hupp. Ms. Kissel, go ahead.
Thank you for allowing me to address you. And I'm in no way trying to negate my obligation to keep abreast of the laws or current regulations related to the reporting or my lack of knowledge as a pharmacist in charge. I mean, I realize that's not an excuse. Many times during my employment with Albertsons as pharmacist in charge, which was from April 9th to when I was placed on leave on 10/21, there were many discrepancies that happened, usually after I had been off for 2 or 3 days in a row. and they were placed on the back counter by either the staff pharmacist, Jocelyn Morris, the mini floater pharmacists that we had, as she was on personal leave for 2 months, or the technicians. And they would leave me a note detailing what the issue was. And I would go through the diligent process of going through all the invoices, running the reports, and trying to find why the discrepancy was happening. I would find that they may have used the wrong NDC. Look at all the medications that were from the same manufacturer in similar size bottles to ensure it wasn't misshelved. Check the EPS site in the system and the EPIL side of the system to ensure both sides were properly updated. Look at all the return to stocks and make sure that those were done properly. Inputting in the order adjustment because of 2 different NDCs, incorrect count and outdates, returns, recalls, various other things. But on the evening of 10/17, it was 11 p.m. or after, and the pharmacy closes at 8 by the time I was able to get to this order. The order arrived anywhere between 9:30 a.m. and 10:30 a.m. and sat there all day. It was unpacked, but not put away. Throughout the day, the technicians would put away the rest of the order, including 3 through 5s, class 3 through 5 drugs. And then when I finally started to invoice and put away all of the class 2 drugs that were on the back counter, I just filled in. There was actually 222s, which were filled with 20 lines of medication. I filled in the right-hand side and I triple counted. I entered them into both sides of the EPS and EPIL systems. I put all the medications away, and then I was informed by the store staff that the pharmacy that this entire store was closing at midnight, and that I needed to wind it up. So I documented everything I received and signed and dated everything as I usually did, used my biometrics to update each side of the system. And I thought I had done the correct thing. I mean, if I'd intended on diverting or stealing any medications, I would not have put my signature on the paperwork or my fingerprint in the biometric computer system. I did not ever mean to be careless or negligent in my duties.
And if the board has questions at this time.
Thank you, Ms. Kistel, Mr. Hupp. Board members, additional questions for either Mr. Hybert or Ms. Kistel, Mr. Hupp?
May I, Madam Chair?
Go ahead. Thank you, Mo.
Ms. Kissel, you're a pharmacist. You know the answer to this. Well, first, let me ask legal counsel, or maybe offer Ms. Kissel. I'm going to ask about your prescriptions and some of your health history. Do we need to go into executive session so that remains confidential?
Would
I would like to.
We would like to.
May I make a motion to go into executive session for the purpose of confidentiality?
Second. All those in favor?
Aye.
Aye. Any opposed? Ms. Kissel, Mr. Hupp, you'll see a invitation to go into a private room for executive session. So please accept that and we'll continue the discussion there. Board members, welcome back. Dr. Gandhi, do we have everybody? Dr. Gandhi, I think you're on mute.
The room is closed.
Okay, thank you, Lynn. Board members, okay, this is, I guess I'll offer some of my thoughts and then I'll take some additional comments and questions if needed. This is kind of where my head is right now. What we know is that there is a loss of controlled substances during the time in which Ms. Kissel was the PIC. We know that that occurred. At this point in time, the reason for the loss is unknown, but nevertheless, Ms. Kissel was the PIC and was responsible for the control of the drugs at that time. We also know that the 222 form was altered. Ms. Kissel is stating that that was not her. Again, Ms. Kissel was the PIC at that time and was ultimately responsible for the record keeping during the time that she was the PIC. To me, that's the facts that we know. There are a number of other facts, whether or not who completed the 222 form, who altered the 222 form. There's evidence that shows that perhaps Ms. Kissel could be involved, but I don't know that we can fully prove that, at least not in my opinion at this point in time. We don't know per se 100% without a shot of a doubt what happened with the loss. So I do have a strong feeling that Ms. Kissel does have a strong degree of responsibility here because she was the PIC and it doesn't seem like the pharmacy was being appropriately controlled under her control as the PIC. I'll pause there before I to see if there's any additional thoughts.
This is Goodman. I have a question on the PIC. We can't limit the level of responsibility of a licensee, right? It's either we give them a license or not. We can't say in the future you can't have that level of responsibility. Can we?
Ms. Galvin, I believe we put conditions before under somebody that had a probationary license that they couldn't be a PIC.
Was that based on a consent agreement? They consented to not being a PIC, not taking students. We've done those kind of things, but that was always on a consent agreement, if I remember correctly.
That's correct.
Board members, additional thoughts or comments?
I think you summed it up nicely, Ms. Walmsley. I think maybe a civil penalty for failure to control inventory, something along those lines might be appropriate.
That was my thought as well. Perhaps a civil penalty for failure to maintain effective control of controlled substances, and one for record keeping based on her level of activity as the PIC. We have an evaluation that shows that doesn't have any signs of substance use disorder or any of those kinds of things. So I feel like this is a fair way to address the issue.
Yes, and to deal with the actual facts, things that we have. I agree.
So instead of the, in addition to the civil penalty, should we also consider CE on the opioids diversion?
It's not a bad idea.
Good suggestion.
Is that something that's readily available to?
Oh yeah. Oh, these days, yes.
Lots of, okay. I guess I was thinking too narrow.
How many hours?
I would say 6 hours of CE in addition to what's her yearly requirement. That's in addition to the civil penalty.
To be done within
90 days.
And how much of a civil penalty?
Ms. Nair?
I hadn't really come up with an idea yet.
250 or 500 for each.
How many are there though?
I would say that we should cite both our, I'm sorry, 321901.01B30 and R423407. So a simple penalty for each. So two.
Okay. Yeah, 500 per violation, I think sounds fair.
Payable within 90 days.
Yeah.
Okay.
So Ms. Snare, is that a motion?
Yes, I'll combine mine with Dr. Dang's. $500 civil penalty for each violation amounting to $1,000 and 6 hours of additional CE. It would due within 90 days, penalty to be paid within 90 days.
And that's disciplinary CE. And this is for failing to maintain control of controlled substances and failure to maintain adequate record keeping.
Correct. Thank you.
And I second that.
And we will need a roll call.
All right, motion by Ms. Snare, second by Dr. Dang. Any additional discussion?
Jennifer.
All right.
I'll take care of the roll call. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus? Mr. Minkus?
Aye, I'm sorry, I had my mute on.
Mr. Leba is recused. Ms. Lahan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Yes.
Ms. Snare?
Aye.
I have it. Thank you, Ms. Kissel. Mr. Hupp, appreciate your time and patience in resolving this case. The board staff will be in contact with you. Thank you.
Thank you very much.
Thank you so much. Thank you for your time.
Okay, returning back to the agenda. I believe, and I will ask Jennifer if we have completed all the agenda items that are due for today. We do have a couple more conferences, but I think those are either tabled or coming at a later time, I believe. And maybe Ms. Dodge is in the know on those two, D and E as well.
D and E are on the agenda for tomorrow.
Okay, thank you. Okay, so having said that, before I go to call to the public, I just want to reach out to board staff. Have I left anything off, or do you need me to return to anything before we recess for the day?
No, Mr. President, I think we have those two applications still for review, but we'll hold off till tomorrow.
Okay, thank you. Having said that, we'll go to call. And I will wait for direction from board staff and Lynn on if we are clear to conclude.
This is Jonathan Hupp, counsel again from Ms. Kissel. I'm sorry we logged off, and I don't know if anyone can hear me, but there was one other matter we need to discuss.
Mr. Hupp, this is a call to the public now. You're welcome to make a statement, but the board is not able to respond to you since it's not on the agenda.
Well, was there a matter, Mr. Hupp, additional matter on the agenda involving Ms. Kissel?
Yeah, I believe because of, as we mentioned, the renewal that was, I forget how we classify it, but she was given a license until December 11th with the pending renewal application So the board did not address, I guess, granting the renewal ongoing or what?
I would imagine, and I don't know if staff is on camera or Jennifer, that the license will be extended until you get the consent and she signs the consent and that it's accepted.
Okay.
That's true. And we'll be working on that right away, Mr. Hub.
Okay, thank you. Just wanted to make sure.
Thank you.
Mr. President, the number's been posted long enough for someone to reply. It doesn't look like we have anybody.
Okay, all right. This concludes the board meeting today. Thank you for a productive day. It's a long day, but I think we did some good. I do appreciate that. We will return tomorrow at 8:30. Thank you.
Thank you.
Thank you.
Thank you very much.